and all of this. And what's happening out there?
Party.
Oh, okay. Celebrating Christmas early. She said she just knew it was going to cost her an arm and a leg, and it did not. All right, so your interpreter is in room 2.
Okay.
And so,
I'm gonna park him
okay,
in the run again.
all righty.
Whenever you're ready to,
I'm ready.
we have Mr. Steve. For, Judith Limerick.
What page?
Judith, you're ready to try on things?
What page?
He's on page.
Young's been signed.
Page 19 to down. I'm sorry.
I got Gil Young signed. You were off on part,
Okay.
and I gave it to,
Yeah, I already processed it.
yeah, so I just wanted to inform the judge.
All right. Well, just 1 second. What date do we have him coming back on?
I think he's set for the 6th.
Okay, let me see.
I got a thing.
All right,
Yes.
let me make sure, because sometimes the system is,
Yes.
all right, it's for the 6th. See you then.
Okay,
All right, thank you.
so Gillian is not needed. No, we got his bonds signed. Okay. All right, Judge, thank you for sending me down there.
All right, you're welcome.
Yeah.
All right, who's here on Sing? All right, and where's Sing?
Yes, John Ramirez.
John Ramirez. Good thing.
Yes.
This is a resumption of the motion to suppress hearing.
Yes. All right, can I see the file on Sing?
Yes, ma'am. See?
Mhm.
This one?
Yes.
I can find it.
All right, so with regards to this, the court had heard the evidence in this case. Is there any remaining argument from either parties?
Just from the defense.
Oh, well, let me go on the record if you have remaining argument. I was just trying to see where we are. The court is calling 2025 CR 010203 State versus Fabian Singh. And if I could have parties announced for the record for the state.
Farmer for the defendant.
And are you Mr. Singh? All right, we had a motion to suppress hearing. The court heard this case, the motion to suppress at least on I think December 8th or December 9th. Is that correct?
Something like that.
Yes, okay. And we're here for the court to make its ruling. And I know at that hearing, there were certain things that both parties stipulated to and agreed upon. All right, States has informed the court that they have no further argument. Defense, it's your motion. Do you have further argument?
Yes, Judge. Focus in this case is on the search of the defendant. The court will recall that officers responded to a welfare check call where the defendant was initially seen on the roof of a parking garage. When the officers encountered the defendant, he was on the sidewalk. They detained him and put him in handcuffs. The officers testified that there was no evidence that the defendant was suicidal. And in fact, the incident detail report indicated that the individual on top of the parking garage was not wanting to jump. However, the aggressive nature in which the officers approached the defendant, they immediately grabbed his arms, put him in handcuffs, and started patting him down. And they went beyond the initial pat down into the pocket of his hoodie and found a bottle of twisted tea. The pat down is legally allowed for search for weapons, not for alcohol. There was no indication, according to the officer's testimony, that the defendant was intoxicated at the time of the pat down for weapons. It's clear from the video that they just immediately went into his pocket for that can of Twisted Tea. There was no open container at all found. There's no indication of intoxication. So it's our position that from the very beginning, their intent was to fully search the defendant and find out what he had on his person. Well beyond what was necessary for their safety.
All right. So, Mr. Singh, I want you to know that I've heard all of the evidence that's been presented to the court. My job is merely to listen to the evidence that's presented on motions to suppress, then make a decision based upon the evidence that's presented to the court. Do you understand? And the reason why I wanted this brought back is because I always, even though I say I know the law, which I do, I always like to make sure there isn't something out there that's brand new that maybe somebody, some appellate court just ruled on yesterday, right? I remember and I recall that I did ask parties if there was any case law that said that someone could not be arrested or was not allowed to be arrested for a Class C misdemeanor, to bring that to the court. And I have not received any emails to that effect. So the court will make its ruling. The court will deny the motion to suppress. And counsel, we're off the record. Counsel, do you have all the discovery in this case?
Yes, ma'am.
And state, were you able to tender an offer?
Prior.
Okay. How old are you? All right, Ms. Ferguson,
Yes, ma'am.
if you can bring this back in 30 days for a plea deadline date.
I can do January 22nd, Judge.
All right, we'll come back on January 22nd. Because of your age, I want you to have a chance to internalize everything that your attorney is going to tell you and think about the consequences or the potential consequences on either decision you make. All right, thank you. And thank you for always dressing appropriately for court. Once you sign the reset form, you'll be excused. All right, who else is ready?
Maria Ruth, the same page, Judge, way at the bottom, it's with Renee.
Maria Ruiz?
Is Renee here?
No. Who's next?
That's all we have, Judge. No one signed up yet.
All right, any plea paperwork completed?
Adriana's still trying to swear him in, Judge.
All right, and Mr. McLean, whenever your witnesses and people are here to go, we'll proceed.
I just texted Warren minutes ago.
Okay.
I told Fox, so she should
All right, thank you.
know. Thank you, Judge.
I think everyone's just waiting on people that are in jail.
Okay.
On page 3, on Vincent Bravo, he needs an attorney. Like he did Jonathan Alvarado.
Okay. All right. All right, thank you. And Norma, on page 3 for Marcos Rios, when are you recalling that? Yeah, we can put it second week. All right, Marcos Rios. Hello. Hi, your attorney is actually in a jury setting in Floresville. So we're going to recall this for January 13th, and that will be your plea deadline date. You're welcome. Once you sign the reset form, you'll be excused. Just have a seat and the coordinator will get you a reset. Thank you. All right, you two.
Are you ready for, what?
Bless you.
What page he's on and then what have got. Who is it? In Seriaga? He's on the first page. Three down. Oh, I don't know if Mr. Woodard's, is Mr. Woodard?
No, can you let him know that we're ready?
Yeah.
Another.
Okay.
Yes.
Okay,
Okay, sure. All right, and Norma, on Marino, on page 10, you can recall that back for the 13th as well?
Oh, is that Leon?
Yes,
Yes, ma'am.
yes.
The state asked me to draft this.
No. I mean, I have a
Marco
question.
Rio? You can grab a flower pen and sign that. Excuse me.
Yes.
I would apologize.
Yeah.
Oh, yeah. All right, who's ready?
No one yet, Judge. We're waiting on the inmate.
All right, so just so everyone know, we're taking up a hearing with Mr. McLean at 2. I said, we're taking up your hearing at 2. Is your client is by Zoom?
Yes.
Okay, all right, they'll bring them out. You know, there is a breakdown in transportation.
There's a consent hearing for David Jordan. Our officer is actually on his way.
Okay,
So as soon as he gets here, I can let you know.
all right, awesome.
On that same case, Judge, I'm announcing that ready, so.
Yes,
I do have two, experts that are on 5 students. They're gonna.
Okay. all right, awesome. Thank you. I guess people don't do regular maintenance on the buses that are bringing people over, you know? My brother always told me, he's like, Stephanie, your vehicle will be fine if you do regular maintenance. Change the oil. Yeah, get the brakes taken care of. That, I'm gonna have to knock on wood.
But that's not the right thing. What time is it on?
1:45. Is it this person, someone?
No, it's,
Another one?
oh, you already took the field.
I do, yeah.
It's,
Let's see.
She was right on top.
What's the name of the person?
Um,
I should get a check on one of my
Look at that.
Eddie Sullivan on his DCR.
Rosa Padilla.
And he also has a different first name.
That's just.
No. This man right there. He has like an AKA John or something. That's it. Yeah, on the docket it has the credit for his new case. I just want to.
All right, Rose Padilla, that's who you're already on?
Yes, Judge.
All right, come forward.
Judge, we thought, Rosa Padilla, we thought we had an agreement, but since and the only reason we fled through is because we thought we had an agreement, but since apparently that's not the case, so we'd like to withdraw that agreement.
Okay,
I know. But you put it here.
all right, sure. Her plea of not true will stand for violations 10, 21, and 23. And you all come back here for a contested hearing.
When do we come back?
Nora, when can we fit them in for a contested hearing?
I can do the January 7th.
All right, January 7th will be your contested hearing.
Thank you, Judge.
Thank you.
Judge, I'm sorry, does the number 23 of not true still stand or?
They're asking that that plea of true be changed to not true. Yes,
Thank you.
And who was this?
it is Rose Padilla. No,
No.
that's not gonna
It- it's
happen.
She's gonna have to be in person.
I'm sorry.
It
No,
has to
all
be in person.
witnesses need to be in person.
Oh, even probation.
Yes.
Okay, just-
You're welcome. Oh, Ashley, if I could see you. Did you ever do Maria Ruiz? For her name and yours, I know he's in the back, he's in the hallway in the back.
Yes, sir. No, we'll take some. That's your. They're cooked together.
That's David in a breakout room.
Yes. And yes, I've sent you there.
Yeah. Thank you.
Anyone else ready?
Yes, ma'am, I have Michael Balderas, Tony Hernandez. I'll let you sign in.
Yeah.
So Renee's here.
And Renee is here, Renee here.
What page?
Let's do Renee, I don't see the other gentleman, Renee is for Maria Ruiz, page 19 at the bottom, Judge.
Your Honor,
Yes.
With regards to Ms. Ruiz, just a quick announcement.
Mhm.
The evaluation was
Oh,
done.
just one second. Let me, have to pull it into Odyssey.
Oh, yes, of course.
Okay. All right, yes.
So Judge, she did have the evaluation scheduled for competency. It was conducted on December the third. The magistrate court setting has a setting for December the twelfth, Judge, for the evaluators. Report that's due, so we can see where we're at in competency. I believe there was an issue regarding transport this morning, requesting respectfully, a recess after after January the twelfth of 2026 for status of the competency.
All right, Norma,
Yes, ma'am.
I need a reset date for status on competency eval after the 12th.
January,
Yes.
yes, I can do. We'll do the 26th, Judge.
All right.
Perfect. I get that date down. Thank you.
All right, thank you.
Yeah.
All right, who's next?
Yes, ma'am. David Glennis, page 16, first one.
David, join us.
Well, where the name was up here.
Oh, okay, well, finish talking to probation.
Yes.
Okay. All right, who's next?
I have Michael Calderas on page 8 at the bottom for Mr. Tony Hernandez.
Valderis. Good afternoon. All right, have you all reached an agreement?
No, Your Honor, the plea offer has been rejected.
Okay, Norm, I need a jury trial date. How long will this last?
I apologize, Your Honor. I would expect at least 3 days for the state's cases.
All right, 3 days, Ms. Ferguson.
Yes, ma'am, I can do March 24th.
All right, your jury trial date is going to be March 24th. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have the plea open to the court. Do you understand?
Yes.
All right, just have a seat,
We
counsel.
also have one more matter.
Yes.
We were asking the court to consider modifying his bond condition from full house arrest to partial house arrest or tracking only.
All right, have you all filed a motion?
We have.
They have, Your Honor, the state doesn't have an objection upon proof of employment and verification of employment hours to pretrial services.
Okay.
To modify it to GPS parcel. We would object to traffic.
We would ask the court to allow him to go out and look for work, Judge.
Well, now that days, your employment, you do it online. So,
He's been doing that. Yes. He has tried.
all right. So the court will allow employment, partial GPS for employment only with proof of employment and your work schedule.
Just for clarity, Judge, he needs to find a job first before he can.
He needs to, I mean, he can do it online.
He has, Judge. He's been trying.
Okay.
I do.
Yeah. Mr. Woodard, that I talked to the.
Okay.
All right, and I need from the parties an acknowledgement of discovery signed and, completed, and I'll sign it. All right, thank you.
Picked up that last week.
Thank you.
Thank you, Judge.
Thank you.
Happy holidays. Promise.
Oh, you too.
It's back to. I think he's. No. Okay. I see. I see. Yes, thank you.
Who else?
Yes, ma'am, I have, Christopher Falk on page 73 now.
Christopher Falk. Thank you.
Good afternoon.
Good afternoon. How's it going?
Good, good. Let's see.
Don't speak close to you.
All right, today is plea deadline date, and I'm assuming you want your jury trial?
Yes, Your Honor.
All right, Ms. Ferguson, I need a jury trial date. How long do y'all expect this trial to last?
3 days.
All right, jury trial date, criminal trial division, 3 days.
Family violence.
I'm sorry, family violence. Thank you. All right, March 24th.
Thank you, Your Honor.
And Ms. Ferguson, Mr. Davidson is requesting that Mr. Porter be appointed as the second chair. All right, thank you.
Thank you, Your Honor.
You're welcome. Oh, and counsel, you'll need to do a clothing exchange with him. And according to the jail's rules now, it needs to be done 72 hours in advance.
Okay.
Not more than 72 hours in advance and not less than 72 hours in advance. All right, thank you. Who's next?
Stephen Limon, Judge. I'm just trying to find him on the docket.
That would be for plea, to give Yaya the plea paperwork, really.
It's on page 3. Are they ready?
No, it's just plea paper. I'm waiting for.
Okay, okay. We can reconvene on that, Judge, a little bit?
You gave her the plea paperwork.
Yeah, I gave Yaya the plea paperwork here. I think she was working right for lunch, but I don't know what the status.
All right, can I see the paperwork on Delio? Oh, wait a minute. Here's this. Mm-hmm. This is with Mr. McLean. Are you ready on Delio? Ah, so is George Piero
George Hero is one of my experts.
and Nathaniel Adams?
Yes.
All right, so we're just waiting for them to bring him over. The bus that transports inmates from the jail broke down. So as soon as they arrive, we'll start with the hearing.
Okay.
Thank you.
Make sure.
Anyone else ready?
No, ma'am.
And
We're
you
just waiting
have-
for plea paperwork.
You have a Mr. Limon, is his attorney, supposed to be on, or is he here?
No, he's here. It's Renee.
Okay.
He's been waiting.
Did I have Mr. Limon? Mr. Munoz is the attorney?
Stephen Limon. Are there any applications in this case?
Yes, Your Honor, for community supervision.
All right, Ms. Abrams, application. And he is on page 3. Court is calling 2025 CR 00743 State versus Stephen Limon. Can I have parties announced for the record for the state?
Megan Galloway for the state.
Renee Munoz on behalf of Mr. Limon.
All right, just one. So everyone in the box, y'all need to whisper. I would appreciate it if y'all would whisper in the box, and then when you're before me, don't whisper.
Mhm.
All right, we're back on the record. And are you Stephen Limon?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
That is correct, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Limon, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney?
Yes, sir.
Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Limon, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with driving while intoxicated third or more. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yeah,
Do you believe he has a rational as well as a factual understanding of the charges against him?
in my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Mr. Limon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering into this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 8 years in the prison, $0 fine, no application for deferred adjudication. State recommends community supervision. There's to be restitution to Trinity Key in the amount of $1,806.94. Ignition interlock for half the term.
Or an affidavit of non-driving.
Thank you.
I believe the defendant may not have a contract.
Okay. Or an affidavit of non-driving. And what I can tell you, the court will add to that, no access to any vehicles.
Yes, Your Honor.
And a 2-year driver's license suspension. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation, 200 hours community service restitution, 10 days in the Bexar County Jail as a condition, participation in successful completion of VTC and inpatient treatment through VTC, DWI education and victim impact panel. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offense as charged, how do you plea? Guilty, not guilty, or no contest? State any evidence.
Upper states one in attachment.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, if you may.
Anything you wish to say on behalf of your client?
Your Honor, Mr. Dumont has some root issues relating to substance use, Judge. All of his previous cases have been DWIs. He has not been afforded in those other DWIs the chance for treatment to get a handle on his issues, Judge. He was screened indeed eligible for Veterans Treatment Court. It's a very intensive program, which I believe Mr. Limon would benefit from, being that his military service and the issue he incurred because of his military service are tied with the issues he's currently dealing with now in terms of dependency issues, Judge. So we're respectfully requesting this honorable court follow the negotiated plea bargain agreement for probation with the condition of veteran treatment court judge. Furthermore, if the court would consider in terms of the 200 community service hours, if he does AA and A classes, he may be afforded the opportunity to work his community service hours through the use of those meetings. And if the honorable court sees fit, he has been in custody pending the resolution of this matter. If he could be granted the 10 days Bear County Jail, being the time he did upfront in relation to this case, Judge. Furthermore, he can reside with his mother at her address. And we're requesting this honorable court sees fit for him to be on full house arrest GPS, no access to any vehicles. And that way BTC can set him up with treatments, hopefully at an inpatient facility to get a handle on.
All right. Ms. Abrams, are you ready?
She just walked out.
Okay. All right, this is what the court is gonna do. There's to be a referral to VTC. My understanding, he's already been accepted.
That's correct, Judge.
All right. So instead of referral, I'm gonna order VTC. There's to be 10 days in the Bear County jail as a condition of probation. Once you are placed on probation, your case will be transferred to the Veterans Treatment Court. And if they make the decision that you're not to serve the 10 days, then they can make that decision. The reason why I'm doing that is because if they want inpatient treatment, they may transfer you from the jail and just have someone to pick you up to take you to the inpatient treatment facility. Regular reporting by Zoom or in person, regular random UAs, ignition interlock for half the term, or he can provide an affidavit of non-driving and no access to motor vehicles. There's to be 2-year license suspension, 200 hours of community service restitution. I'm going to allow him to deduct an hour from those community service restitution hours for every sober support meeting he completes. DWI education course, DWI intervention, victim impact panel live, field visits 1 time per month until further notice, full GPS, waive fees. There's to be restitution of $1,806.94 to Trinity Key. Probation is there, and there's to be 8 years in the prison, suspended and probated for 5 years. And there's a $0 fine. Probation, is there anything else? No, he's already been accepted into Veterans Treatment Court, so they'll take care of that. All right, is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing, Veterans Treatment Program, that's a good program for you, right? If you successfully complete everything, when you graduate, if I'm in town, you let me know you're graduating, I'll show up for your graduation.
Thank you.
Okay. So which branch did you serve in?
Marine Corps.
Okay, well, you can do this, all right? If I didn't think you could do this, I would have read that report, and you know what I would have said? I would have said, I'm not following this agreement. So I know you can do it. The state wants you to be successful. Your attorney wants you to be successful. Even though your case is going to be transferred to them, and they'll be in charge of whatever conditions they set for you. If there's anything else you need, you can always come back here if I'm here, all right? All right, good luck to you. You're welcome. Thank you. And Renee, if you let VTC know that if they don't want him to do 10 days, it's completely up to them.
Yes, Judge, I'll update them that the probation is granted at that condition. I'll make that request. Thank you for reminding me.
All right, thank you. Is there anything else? Anyone else ready?
Page 15, one down, Ruben
Graziano,
Francino.
It is
15-1, Judge.
Ruben Cancencia, Cancino? I need to know, those hard Cs or soft Cs?
Casino.
Oh, look at, ah. See, Rick, you're the only one who's representing. Everybody else claims they speak Spanish. They're no help to me.
Yes.
Yes. Yeah, I'm telling you, they're sending me out to the world, not knowing what I should know, but I'm fine with it because it reflects badly on them. They'll say like, where did you learn that Spanish from? Deputy Mejia? Miss Abrams?
Yes.
I said, when I go out into the world and my Spanish is not as it should be, and they ask me where I learned it from, blaming you guys and Deputy Laura and Norma.
Everybody except.
Yeah, Normalata.
Blame you.
Oh, thank you.
All right, so what is happening with this case?
We're asking for a 30-day reset, Judge. This is first setting. We have an offer good for 30 days.
Okay,
In the last couple of days, have got notice of additional discovery. We would, that come back in 30 days. Like I said, we've got an offer available, so.
right. And how do you pronounce your last name?
Cancino, ma'am.
Cancino.
Yes, ma'am.
Thank you.
Cancino, Cancino.
Cancino.
Yes.
All right, Cancino. All right. I can only say it if I do this. Cancino. All right. Can I have 30 days for a plea deadline date?
January 22nd.
All right, we'll be back on January 22nd. If your attorney wants you brought back sooner, he can let us know. We'll place you on the docket sooner. Thank you.
Thank you, Judge. I'll be touch vendor.
All right, who's next?
Did we have, Mr. Woodward on Zoom yet?
Let me see. No.
That's the only thing I have available right now, Judge.
All right. Oh, Bishop, can I see you? Oh, Norman, if I can see you.
Yeah.
All right, just 2 minutes, everyone.
I was joking about that. I was like, it just happened to be that way. It wasn't like I had got all my stuff moved to today because of the trial. It was just like I happened to have a bunch of stuff set today, and I was like, man, I feel like I've been living here the past week and a half.
Yeah. Oh, we're used to it. We're always.
Yeah, y'all are the best.
You're gonna be for reset?
It is, yeah. Sorry, I was just ready. Oops. Yeah.
It's an empty, you have to sign into everything.
Oh, I do.
Yeah, no. Okay. I think it sounds. When you have a chance, just.
Okay. And what is his name?
I should know. Alvarado, Francisco Alvarado.
Yes. What, the one I just did the plea? Oh, no, he can't be a resident of Wilson. He's gonna be here in Bear County. No, yeah, he's in Bear County. He's staying for. Okay.
He's on page 13, Judge.
Thank you.
I'm gonna go tell Yaya.
All right, thank you.
Judge, whenever you're ready for a reset, I'm ready.
All right, just give me one moment.
Yes, ma'am.
All right, who's ready?
Yes, ma'am. I have a Vicente Bravo, page 3, 2 down for Mr. Alvarado. Is he here? Huh? Alvarado is the attorney.
And what page?
I have it on page 3, 2 down.
Ah, all right, thank you. Vicente Bravo. Hello, and I know you were recently appointed.
Yes, Judge.
And do you need a reset for discovery?
Yes, ma'am.
All right, and I need 30-day reset for discovery.
Miss,
I know. All right, this is what we're gonna call it for. We'll recall you for January 22nd.
Okay, thank you, Judge.
Thank you. Once you sign the reset form, you'll be excused.
I'll get
You're
that
welcome.
for you in just a moment, sir. And I do have an MTR whenever you're ready to.
Yes.
That's for Miss Rochelle Acevedo.
Who's here on Richard Cantu?
All right.
Yes.
No, it's
Richard.
Richard. Cantu.
I think that's okay. I thought there were gonna be two people on this. All right, are you all ready to proceed on the NTR?
Yes, sure.
Court is calling 2021 CR 11554 State versus Richard Cantu. Can I have parties announced for the record for the state?
Michelle Savetta for Mr. Guthrie.
And are you Mr. Cantu?
Sure.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney, and did you understand it?
Yes.
Are you the same Richard Cantu as placed on deferred adjudication in 2021 CR 11554 for the offense of obstruction or retaliation on September 16, 2024 for a period of 3 years? Is that you?
Yes.
All right, state.
Violation of condition number 4 in Bear County, Texas, the defendant Richard Cantu did then and there fail to report to the supervision officer as directed for the months of August, September 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
We would abandon the remainder.
Any objections to the waivers? Did you understand by pleading true to violation of condition 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4?
True.
No. Are you pleading true to number 4?
Sure.
Do you understand? No. Listen to me. Are you pleading true to violation of condition number 4? Yes or no?
No. Don't know what I mean.
Oh, so this is what it means. The state is saying that you did not report. Do you understand that?
Yes.
Did you report?
No, I couldn't find the.
Nope, nope. I just want you to answer my questions. All right. So you have just pled true to the fact that you didn't report. Do you understand that? Now, whatever agreement you worked out with the state, I don't have to follow that. Do you understand? I can send you to prison for 10 years. Do you understand? So knowing that I can send you to prison for 10 years and up to a $10,000 fine, do you still want to plead true? Yes or no?
No.
All right, he doesn't want to plead true.
True for the probation office, I could not find the probation office. Yeah.
All right, so here's the thing. This is his second motion to revoke. I know he know what's going on here. So I'm going to explain it to you again. And if you wanted to proceed with saying yes, no, not answer my questions, we can do that. And this will be recalled for a contested hearing. The state will bring in a probation officer or whatever witnesses they need. Do you understand?
Yeah.
Now,
I could not. find
now,
the-
listen to me. Are you pleading true to not reporting, yes or no?
No.
All right, so we need a contested hearing. All right. What date for a contested hearing? Failure to report.
I can do the 7th
Do you want to do the 7th
or the 9th.
or the 9th? Now it's up to you. If you want to bring it back for another day, that's fine.
We do second.
All right.
15th.
All right, we'll see you back on the 15th. The state will call whatever witnesses they need to call to seek to prove the failure to report. And what I can tell you on failure to reports, usually the person that needs to be called is the probation officer. And that probation officer is going to come in and say, either you reported or you did not.
I did not report. So I know I didn't report to nobody when I got released the 3 times.
So I don't understand why you're not asking my questions.
But to be saying, yes, I did not see no one, or no, I never went into the door. I'm saying that I never went to see the probation officer, because I never saw him, I never got reported to see him.
Mhm,
I never got his address or his phone number to see.
mhm.
Yes, I wanna move forward with my case. I wanna take it to. I wanna take it all the way, like guilty and not guilty, I plead guilty. I plead no contest also, but I never saw my probation officer when I got released. I never had ever seen.
You want to talk to him some more? All right. Anyone else?
Angel Antonio Cantu.
And Mr. Delio is still not out here? Okay. Hi.
Morning, Judge. Or, well, not morning.
Are you all ready to proceed on this motion to revoke?
Yes, Judge.
All right, court is calling 2022 CR 1107 State versus Angel Cantu. Could I have parties announced?
Rick Pena for the state of Texas.
Warren Gary for Angel Cantu.
And are you Angel Cantu?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Angel Antonio Cantu who's placed on deferred adjudication in 2022 CR 1107 for the offense of indecency with a child's sexual contact on August 25th, 2022 for a period of 10 years? Is that you?
Yes.
State?
Yes, Your Honor, violation condition number 13A. On or about the 11th day of September 2025 in Bear County, Texas, the defendant, Angel Antonio Cantu, did then and there fail to comply with the instructions of the Bear County Community Supervision and Corrections Department Sex Offender Program, and that the defendant admitted to having internet identifiers on Discord, Kick, and other social media platforms, violation of condition number 13.
How do you plead to that? True or not true?
Sure. Violation condition number 13B. On or about the 16th day of September 2025 in Bear County, Texas, the defendant, Angel Antonio Cantu, failed to comply with the instructions of Lone Star Offender Treatment Program, his court-ordered sex offender treatment program, in that the defendant failed to progress toward reasonable treatment goals and was terminated from treatment in violation of condition number 13B.
How do you plead to that? True or not true?
Sure. Violation condition number 13JA. On or about the 11th day of September 2025 in Bear County, Texas, the defendant, Angel Antonio Cantu, did then and there failed to comply with the instructions of the Bear County Community Supervision and Corrections Department Sex Offender Program, and that the defendant admitted to accessing the internet on an unmonitored device in violation of condition number 13JA.
How do you plead to that? True or not true?
True. Violation condition number 13L. On or about the 11th day of
Let me just stop you all. Are you all doing 13L but not 13F?
13F and 19 are going to be waived by the state.
Okay. Do you really need 13L?
You can waive 13L as well.
No objection, Judge.
All right, did you understand by pleading true to 13A, 13B, 13JA, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to 13A, 13B, and 13JF?
Yes, Your Honor.
Court will find 13A, 13B, and 13JF true. Is there a proposed agreement?
There is, Your Honor, that is to grant the state's motion, revoke the defendant's probation, adjudicate him guilty, and sentence the defendant to 8 years in prison.
All right. Why should I follow this?
So Judge, Mr. Cantu has, so these allegations arrive from Mr. Cantu's own statement. So he was self-disclosing of these things during the process of which he was getting treatment for under the sex offenders program. He had been asked by his counselor, through the various ways they go through counseling, how are you doing? What's going on? He self-reported these incidences. The thing that what I understand from how I've looked at this case is that my client has had struggles with doing probation. I think ultimately probation is good because it helps us find these issues where we have problems that kind of relapse up. I think given that Mr. Cantu has indicated, we're here today because he's not hiding anything. He's not proud of what he did, and he has indicated to me that he understands that this is, it's not good, and he, shouldn't have been doing it in the first place, Judge.
So has he had contact with the complainant?
Judge, it is my understanding that he has not. I do have the mother of the complainant here is present, if you would like us to call her a judge.
I mean, well, you talked to her, is she saying that he hasn't had contact?
That is what she said, Judge, and I understand that's only her statement.
All right, and how old is the complainant?
I'm gonna get her.
How old is the complainant?
My mother. 14, Your Honor.
Okay.
Judge 14 at the time of the
Can I get that? Yes.
Oh, okay. I do remember this case now. And I'm sorry, could I have the trial court certification? All right. And I'm sorry, state, why should I follow your agreement?
In the convention of justice with this coming about. Fair prison sentence from the state point of view.
I'm sorry?
It's a fair prison sentence from the state point of view.
So what has he done on probation?
I'm sorry, his probation officer was here a little bit earlier.
Okay.
But according to the court summary, there has been 3 negative UAs. He was in sex offender treatment, but there was some issues there. As far as anything else, he was on the so moved caseload, but there's a total credit of $1,163 toward his supervision fees. But other than that, Judge, nothing.
Are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court will revoke, find you guilty, sentence you to 8 years in the prison. There's to be no contact with the complainant, no residing in households with minors. No contact with minors. And chapter 62 registration. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement? I'm sorry, I need that back. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Could I have his file back, please?
Yes, ma'am.
With the trial court certification? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Your Honor.
Sure. All right, good luck to you.
Thank you, Your Honor.
All right, who else has a contested hearing with witnesses?
Mine is separate contested, but we spoke yesterday
Yes.
about getting.
Who's your client?
His name is Alonzo Taylor, Judge. He hasn't been brought up yet, but I have heard.
Oh,
Scalloway.
what page is Alonzo? Oh,
Page 18, Judge.
18. All right, Norma, if you can set this, it's set for a contested. If you can set it for the 3rd week in January.
I can do the 22nd, Judge.
The 27th?
The 22nd?
All right, 22nd.
Yeah.
All right.
Thank you, Judge.
It's Alonzo Taylor.
Yes, yes. Whenever you're ready,
Yes.
another one, Judge.
What, contested?
No. Reset.
I have a contested one, Judge.
All right, then we'll take your contested matter, but what's the reset?
It's Jonathan Alvarado's client, Caitlin Jeffries.
What page?
She's on page 19, Judge. 4 down.
And this is a probation. The reset after she was granted probation.
Okay. All right, so what is the status on the evaluation?
So Judge, one of the reasons it got reset was because Ms. Jeffrey was having her parole hearing. In between last setting and this setting, she has had her parole hearing and they have decided to continue her on parole, but she is going to be sent to Safe P.
Okay,
One of the questions the court has was she had been referred for further evaluation regarding DDRF, and so the court was going to consider that. Depending on what happened at that parole hearing. Now, Judge, given that she's been ordered for Safe P, as courts aware, it's a super long program of 9 months, I believe it is. I would just ask that she be allowed to start her probation once she gets out of Safe P, that she's already gonna have.
no, I mean, she will be on probation here already. It's just that
Right,
she's gonna have Safe P.
as a condition.
Judge, I'm sorry, this is Caitlin.
Yes.
Okay, so Judge, there was, you just signed an order and amended conditions for her to do DDRF.
Okay.
There was a Tacoma already completed, I believe, and you signed paperwork just recently, maybe days ago, for DDRF, correct?
No, I never signed for DDR.
One second.
And
Ms. Abrams, maybe I have it wrong in my system.
Consider if parole is gonna continue her. Without any added conditions, if the court was gonna allow her to do outpatient treatment as part of the probation.
All right, if you can do me a favor, just confer with Ms. Abrams and I can take up the plea for Mr. Woodard.
Yes, sir.
Matthew and Sariaga. Court is calling 2025 CR 007924. State versus Matthew and Sariaga. Can I have parties announced for the record for the state?
State?
Defense,
David Andre Woodard for Matthew.
are you Matthew and Sariaga? Counsel, have you received all discovery? Did you review it with your client?
I have, Judge.
Court will find the state is in compliance with discovery. Mr. Insiriaga, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it? You're charged with aggravated sexual assault of a child. That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Judge, and he was.
Mr. Insiriaga, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Satisfied with the way you've been represented? If you're not a US citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at a cap of 10 years in the prison. There's a $1,500 fine. The state is opposed to your application. There's to be Chapter 62 compliance, no contact with the complainant, and you're subject to the full range of punishment if you fail to, do y'all mean this to say fail to appear for sentencing?
Yes.
All right, any objection to the court changing the word PSI to sentencing?
No objection from defense judge.
And state?
From the state.
And you will be subject to the full range of punishment if you fail to appear for sentencing. So your plea will still stand. It's just that your agreement will change to you'll be subject to the full range of punishment instead of 10 years. Do you understand? Sure.
So I would, probation.
No, this is what is going on. The state is opposed to the court granting you probation. You can still apply, but there's not an agreement. The state is not saying they want you to have probation. They're saying they do not want you to have probation. Do you understand? Now, with regards to you're not appearing, I'm going to give you a date to come back for sentencing. If you don't appear on that date, your plea bargain agreement for a cap of 10, which means that the state would only be able to ask for 10 years, will change to the state will be able to ask for life. Do you understand? Did you understand that to be your plea? Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? The waiver of appeal paragraph just tells you whether or not you have a right to appeal certain things. It's this paragraph. Did you review that with your attorney? Did you understand it and sign it? By signing that, you're waiving your right to appeal. The only items that can be appealed are motions that your attorney has filed, and I've ruled on them. Do you understand? Counsel, have there been any such motions?
No, Your Honor.
All right, then to what you're being charged with, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State it offers State's Exhibit 1 and all attachments, Your Honor.
No objections, Judge.
And state, have you spoken with the complainant?
We have, Your Honor.
All right, you may be excused.
Judge.
Did you review this document called waiver and stipulations? Again, do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, today, there will be no witnesses, live witnesses. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. After reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will defer finding of guilt as you've applied for deferred adjudication. Counsel, are you requesting a PSI and TAP evaluation?
I am, Judge.
Is there a need for a mental health evaluation?
I believe so, Judge.
All right, I need a PSI, TAP, and mental health evaluation, Ms. Abrams and Ms. Ferguson. What date?
I can do February 12th.
All right, once you sign the reset form, you are excused. I will base my decision upon your application upon any information that's given to me, all right?
Oh. So my brother, he's in the army, was gonna, like, how do I have him, like, get a contact with child support?
Oh, no, what will end up happening is you'll speak to your attorney about that. And whatever information you want me to know, just let your attorney know, and your attorney will let you know if they think it's appropriate for me to know about that or anything else. Just go through your attorney, okay?
And I won't get back to you.
I'm sorry, what?
Can I ask one more thing?
Sure.
I was trying to see if I could get permission to go to my child's birthday.
Oh, you'll have to speak with your attorney, and your attorney will have to file a motion for that.
Yes, and I asked him, said he was gonna talk to you. Said he.
Okay. All right, and is the complainant the mother of this child? Oh, no.
What do you mean?
I said the complainant in this case. All right, then your attorney, once your attorney confers with the state, the court will consider. All right, Ms. Ferguson, I'm sorry, what date?
February 12th.
All right, so we'll be back on February 12th, Mr. Woodard.
Okay, thanks, Judge.
All right, thank you. Once you sign that, you'll be excused.
It was a PSI intact.
Yes, and Nick evaluation.
You get a flower pin and try what's this dependent.
All right, Rochelle, are you ready? So what does your client wish to do? All right. Court is calling 2021 CR 11554. We're back on the record and Richard Cantu. All right, Mr. Cantu, the last time we were here, you pled true to violation of condition number 4. Is that correct?
Yes.
All right. Did you understand by pleading true to violation of condition number 4, the court could grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yeah,
Knowing that, do you still wish to plead true to violation of condition number 4?
yeah.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, it is to grant the state's motion, revoke the defendant's community supervision and sentence him to a term of 4 years in the prison, and then the state would be taking into consideration clause number 2025 PF 43375.
All right, is that your agreement?
It is, Your Honor.
Mr. Cantu, are you asking the court to follow that agreement? Are you waiving your right to appeal? All right, the court will follow your agreement. Odyssey is slow. All right, the court will find violation of condition number 4 true. The court will follow your agreement, find you guilty, revoke, sentence you to 4 years in the prison, give you credit for any time served, take into consideration 2025 PF 43375. There should be no residing in households with minors, no unsupervised contact with minors. I'll state you may be excused. And the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yeah.
All right, good luck to you, sir.
Thank you, Judge.
Thank you. I think that goes to them.
Oh,
I could be wrong. All right, who else has a motion, a contested?
I have a reset ready.
All right, who's the reset then?
Brian? Is page 8 down?
Andrew Barham.
Good afternoon.
Good afternoon. It's been a long one.
Yes.
All right, where are we on discovery?
Judge, the state has provided discovery, however, I have not been granted the access into the portal. And in fairness, I just substituted into this case in November. And we just had competency restored last week. So I was a little late to the game getting into the discovery portal. I did review the state's file today. The state and I briefly discussed the case, exchanged offers. I spoke with Mr. Barham about where we're at. We're just not ready to enter into a plea today.
All right, Ms. Ferguson, I need a plea deadline date of the third week in January, please.
Yes, ma'am. We can do the 20th.
All right, and I would tell you on these cases, it's always a quick turnaround so that people don't lose competency.
Judge, I'm fine with that.
Okay.
In fact, I think we could probably even do sooner than the 20th, just because I have a jury trial set in Bastrop County that.
Oh, well, if you're able to come back sooner, just ask the coordinator and they'll put it on the docket sooner.
Okay.
All right, thank you. Do you have any questions, sir?
Not this time, Your Honor. Thank you.
All right, thank you. All right, who's next?
Do you have Nicholas House already?
All right, the competency with Ray Martinez. What is his client's name?
It's contemporary.
All right. Did I say Daniel Jimenez?
David Duenas.
Oh, David Duenas.
One second, Judge, I've been right at these.
Oh, it's David Solomon Duenas.
Yes, ma'am.
All right, court is calling 2023 CR 2677 State versus David Solomon Duenas. Could I have parties announced for the record for, and for the defense?
Raymond Martinez.
And are you David Solomon Duenas? Did you review the document entitled Motion to Revoke Community Supervision with your attorney? This is incorrect. Let me see. Ah, this was a jury trial.
Yes.
Okay. Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same David Solomon Duenas who was placed on community supervision by jury in 2023, placed on community supervision by the court, which followed the recommendation from the jury in 2023 CR 2677 for the offense of aggravated assault with a deadly weapon on January 23rd, 2024 for a term of 5 years? Is that you? State?
Violation condition number 1, on or about the 9th day of October 2025 in Bexar County, Texas, the defendant, David Solomon Duenas, committed the offense of assault on violation condition number 1.
How do you plead to that? True or not true?
Violation condition number 2, on about the 12th day of September 2025 in Bexar County, Texas, the defendant, David Solomon Duenas, did then and there illegally use a controlled substance, namely cocaine, in violation of condition number 2.
How do you plead to that? True or not true? All right, state, call your witnesses.
This time, Your Honor, state will call Terrence Williams.
All right.
And Judge, before they call the number 1, while they try to prove that one up, I wanted the court to be aware that we would prefer to have our jury trial on the number 1 violation. And it's been indicted already. We're ready to go on it as soon as the court could, but because of the different standard of proof, I think in all fairness, my client should be afforded his right to a jury trial on that.
All right, we're going to proceed. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, state, you may proceed.
Thank you, Mr. Williams.
Good afternoon, sir.
Could you please introduce yourself to the court?
My name is Terrence Williams. I'm a CSO for 30 times
How long have you been a CSO with the Bexar County, with Bexar County?
since 2025.
In your employment with Bear County probation, have you come into contact with someone whom you now know to be David Solomon Duenas?
Yes, sir.
You see that person in the courtroom today?
Yes, sir.
Could you identify him, please, by an article of clothing that he's wearing?
Black vest, black long sleeves and glasses.
Mr. Williams, can you please tell the court, when was your first interaction with Mr. Duenas?
September of 2025.
And at that meeting, did you go over anything with Mr. Duenas?
Yes, went over, asked him a series of
We got the
questions.
non-responsive judge. You just asked him, did he go over things with him? The answer is yes or no.
Yes.
What things did you go over with Mr. Duenas on that day when you first met him?
So some things I went over were his employment, place of address, and had he had any contact with law enforcement, the police, or any arrests.
And what was the purpose of that last question for having any contact with law enforcement or arrests?
The purpose for that question was to determine if he was violating any conditions under his probation.
And what condition of probation would that be?
Violations of committing a new offense.
No further questions this time, I'll pass the witness.
No questions, Judge.
All right, thank you. Is this witness excused or subject for recall?
Excused by the state.
Judge, I'm not really sure what role he plays in the overall scheme of my client's probation. I don't know if he's a regular probation officer or just, it was just that particular day.
Mhm.
If he's a regular probation officer, I'd like him to stick with
I understand this.
that. Okay.
All right, so if you could remain, thank you so much, and thank you for your patience. All right, call your next witness.
Your Honor, this time state calls Miss Karina Luvano. If I may just check.
Sure.
Thank you. Ashley's name.
And what is happening with De La O? De La O? What is happening?
She's back here.
Oh, he is, okay. I don't know where, I think they went in the talk in the hallway. All right, thank you.
While we're waiting, state's not gonna waive their right to a jury trial with this number one violation.
Oh, we're not here to, we're only here on the motion to revoke. Okay,
Apparently she had the restaurant.
okay, that's okay. All right, are you all planning to address violation of condition number 2 or no?
No, you aren't. Just number one.
All right. Oh, while they're doing that, if you could grab a trial court certification of defendant's rights to appeal. I don't know what my ruling will be, but I always require that they are filled out. It's on the wall. Yeah.
All of them.
They're waiting for. Estamos bien. Ujú.
All right, if you'll come forward, please.
Do you want me to put it?
All right, just keep your voice up so defense counsel can hear, I can hear, and the state can hear, all right? Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Everyone, please whisper. If you'll state your name for the record. All right, you may proceed.
Thank you, Your Honor. Good afternoon, Ms. Lozano. Do you know someone by the name of David Solomon Duenas?
Yes.
How do you know him?
My ex-fiance,
How long have you known?
around 5 years.
How would you describe the nature of your relationship with Mr. Duenas?
Can you ask that again? Can you ask that again, please?
How would you describe the nature of your relationship with Mr. Duenas?
I don't understand. Yes.
Have things always been good between you two?
For the most part, yes.
Have things ever gotten physical between you two?
Yeah.
Was there an incident that took place on October the 9th of 2025 where things got physical between?
Objection, leading the witness, Judge.
That'll be sustained.
Hold on, let me go question, and answer your question. But has there recently been an incident that took place between you and Mr. Duenas?
Yeah.
Do you recall when that was?
Not the specific date, no. I'm going to ask you a question.
No, not while you're under oath.
Okay.
Um, no. So what ends up happening at this stage, they just ask you questions. The state will be able to ask you questions. Just listen to his question, answer his questions. And then if the defense attorney wants to ask you a question, just listen to their question and answer their question. If for any reason you don't understand the question that's being asked, just let them know you don't understand it, okay? Because sometimes attorneys can use a lot of legalese. All right. So if it's something you don't understand, just let either party know you don't understand it, okay?
Can I jump in on that question,
you,
Judge, just to clarify for the court?
I can, I have a question.
No, yes, proceed.
Thank you. Mr. Lerner, do you want to be here right now?
I do not.
You're here because you're under subpoena?
Yes, only because I'm under subpoena.
Do you recall meeting with the police recently?
Yes.
Do you recall making a statement to the police recently.
Yes.
We're looking at a copy of the report, will refresh your memory as far as when that interaction with the police took place.
Yes.
Judge, I'm gonna object to her refreshing her memory with something that's other than her statement. The police report is the officer's version of what he did at the scene, not what she said. She needs to look at her own witness under the Gaskin rule. She's got to see her own statement that she wrote or video statement. Refreshing her memory with somebody else's is inappropriate.
No, that's not the law. The objection will be overruled. Yes.
Ms. Levon, if you could look at this page, please, look at it to yourself, do not read aloud from it. And look back at me once you feel like your memory has been refreshed. Has your memory not been refreshed, Mr. Levon? Do you remember when this incident testified earlier about things being physical between you and Mr. Duenas took place?
Objection, leading the witness, Judge.
Overruled.
October 9th, 2025.
Can you please describe to the court how things began on that day? Can you please describe to the court how your interaction with Mr. Duenas began on that day?
We had a disagreement.
What was the disagreement about?
Me asking for the apartment key, his copy
Of your apartment?
of his apartment.
Of his apartment. Where do you live?
No longer in that apartment.
Okay. You described wanting a key for that apartment?
Yes.
Why did you want that key?
He no longer lived there or paid bills, so I didn't want him to have access to the apartment.
Okay. At that time, who lived in the apartment?
Myself and my 3 children.
Okay. Do you and Mr. Duenas share any children in common?
Yes, we share 1 child.
Okay. How old is that child?
She's 3.
What's her name?
Ariela Dueñas.
Okay. Does he have like visitation rights with that child? With that child?
No set visitation rights, no.
Like no formal?
No formal,
Is there
right?
like an informal agreement between you two?
Yes.
Okay, and what is that agreement?
He would just pick her up when he had time or was available.
Is that what he was trying to do on this day?
Yes,
He was trying to pick up the child that you have in common?
yes.
Okay, and happened at when he requested that.
We agreed for him to pick her up.
Pick her up at your apartment?
Yes.
Okay, so did he go to the apartment?
Yeah.
What happened when he got to the apartment?
He went upstairs for my daughter. She was sleeping.
There's in the apartment?
Yes.
Okay, and what happened after that?
After he went upstairs for my daughter, he came downstairs. I asked him for the apartment keys.
What happened when you asked for the apartment key?
He told me that I didn't need it back.
How did he react? I guess what was his mannerism at that time?
Calm.
What happened after that?
He made a comment that upset me. So I guess we got into a disagreement.
Okay, so you got, would that be like an argument?
Yes, an
Verbal
argument, yes.
What happened after this verbal argument took place?
I don't remember like the specific sequence of it.
That's fine, to the best of your knowledge. Tell the court what happened after this verbal argument took place.
He I guess charged at me
Okay, and where were you in the apartment he charged you?
It's like an open space, so he was closer to the, it's all like the same space, but he was closer to the front door and I was in the dining room.
The dining space is- It was at that point that he charged at you while you were in the dining room?
Oh, I forgot that he set my daughter down,
He sat your daughter. Okay.
set her down on the
Set her down.
sofa, she was sleeping.
And so it was after that that he charged at you while you were in the dining room?
Objection leading the witness, Judge.
All right, that'll be sustained.
Was it after that when he charged at you?
Yes.
And what happened when he charged at you?
I don't really remember what arm grabbed my neck or how I was positioned. I don't remember if I gave him my back. Or if it was head front, but his arm or his hand was around my neck.
His hand was around your neck?
Yes,
Do you recall if you were able to breathe at that time?
I was able to breathe, yes.
Do you recall how long his hand was around your neck?
No,
But you're testifying to the judge right now that he put his hand on your neck
yes,
right after he charged at you?
yes.
Okay, and what happened after that?
After that. I want to say that we had another verbal argument.
That's what it is. I'm gonna take one step back. I forgot to answer your question. How did your neck feel when he put his hand around your neck?
I don't remember how.
That's fine. Okay, so then you had another disagreement. Is that what you just said?
Yes.
Like another argument?
Not necessarily argument, but well, I guess yes, we were shouting at each other.
We're shouting at each other. What happens after you guys are shouting at each other?
I don't remember. I don't remember if he was leaving at that point or if that's when he had charged me again.
Okay, so you don't remember specifically the sequence, but was there a second time when he charged at you?
Yes.
What happened during that second time that he charged at?
He went, I don't remember if I cowered. I don't remember if I gave him my back or if he charged me like head straight, but he went for my neck again.
And was he able to put his hands around your neck this second time?
Yes,
Were you able to breathe?
yes.
Do you remember how long he had his hands around your neck the second time?
No.
How did your neck feel that second time after he put his hands around your neck?
Honestly, I didn't have any neck pain until the following day.
Oh, okay. Right, so what happened after this second time that he charged that you and put his hands around your neck?
We got into, well, I want to say at that time, I was telling him that I was going to call the police.
And what did he do in response to you saying that you were gonna call the police?
Broke my phone.
He broke your phone. Okay, and what did you do after he broke your phone?
Well, I don't remember. I know he mentioned something about calling.
Objection, not responsive, Judge. The question was, what did she do?
Overrule.
You may continue to answer.
The disagreement, I know was something, he had mentioned something about, like calling whoever I wanted, calling the police, calling my brothers, calling a boyfriend. And that's when he broke my phone.
Oh, so that's when you broke phone. What happened after that?
He choked me again.
So this would be the third time that he choked you?
I don't remember.
Well, you testified earlier that there were two prior times when he had choked you, right? So this is the next time. That's just the third time after the first two. Is that correct?
The third, yes.
Okay, so what happened this third time when he choked?
This third time. I think that's the one where he, ordered me into the kitchen.
Okay, so he cornered you in the kitchen. What happened after he cornered you in the kitchen?
And that time I couldn't breathe.
That time he choked you, you couldn't breathe?
Yes,
So he had his hands, did he have his hands around your neck?
yes.
Do you remember how long he had his hands around your neck?
I don't remember if it was both hands or how long.
All right, any other questions? Or do you pass the witness?
This time?
Defense?
Ms. Lavana, you started with telling the court you were not really interested in being here to testify today, is that right?
Yes.
And there's multiple reasons for that, correct? One of the reasons is you don't remember all the things you said at the police that day. Is that fair?
Yes.
There's another reason because when the two of you get into arguments, you both get physical with each other sometimes. And you're concerned about being under oath in front of a judge, admitting to striking or assaulting my client. Isn't that true?
Objection, Your Honor, to television.
Overrule.
Well, let's go back. Let's go back to the beginning. How long did you and David live together?
I want to say 4.5 years.
Okay. And in those 4.5 years, there were previous arguments that turned physical, correct?
Yes.
And in some of those instances, you assaulted David, correct?
Yes.
And in some of those instances, you used weapons and or whatever you could find to put your hands on to assault him, correct?
What are like?
Well, for example, there was an occasion where you hit him with a frying pan or a pan of some kind in the kitchen and split his head open, correct?
And self-defense, yeah.
So you and he have had this kind of a relationship up until you separated,
Yes.
right? And so, to be honest, he was coming over there to pick up your daughter, y'all's daughter, and take her for the evening, correct?
Yes.
And when he found that she was asleep, he changed his mind and said, I'm gonna let her sleep. And he decided he was gonna leave her there, right? Do you remember that? Okay, isn't it true you told him, no, I already have plans, I was gonna go out, and you need to take her, I can't leave her here by herself. You don't remember that conversation?
No, I never said that I was gonna leave her, so.
Well, not that you're gonna leave her by herself, but she was too young to be in the house with your older children. Correct?
No,
That wasn't a point of contention.
I did mention that I had plans that night, yes.
So the person who got upset or the problem that occurred was when you got upset to him choosing to leave the child and not take her because she was already asleep. Object this argument.
Overrule.
But that's why I'm not having this argument.
In essence, you were the first one to get upset because of his taking that position at that point.
I didn't get upset, no.
Okay. Now, when David eventually came down and had the baby in his hands, isn't that when y'all were still arguing? He never, well, you say he put the baby down, so at some point he must have had her.
Right, yes. we
Okay.
had.
And isn't it true that you became physical with him while he was still holding the baby in his hands?
That's not correct.
Okay. But at that point, you were already arguing.
It wasn't really arguing, we were just exchanging words.
Okay. Well, then what would be the need for him to put the child down? Isn't it because you were approaching him in an aggressive fashion? Okay. So he put her down so that he could commence the assault on you. Is that the position you're taking?
Right.
Okay. So, Ms. Lubano, what statement or information did you review before your testimony here today?
Like if I read my statement.
Right. Do you have a handwritten statement that you wrote that you might have read before you came down here today?
No.
Okay. Did you have a video statement that you watched?
No.
So you don't remember, you didn't refresh your memory before you came to testify about what you told the police? So is it your testimony that he never restrained you, put his hands on you or anything like that in response to what you did first?
No.
He didn't do anything.
Right.
He just unilaterally decided, I don't like the way this conversation is going, I'm just gonna choke you. Is that what you're telling the court?
I requested the key for the apartment. And that's what upset him, yes.
Now, did you request the key or were you being demanding or physically aggressive with him?
Yes, that's your question.
Overruled.
Can you ask that again, please?
Well, the way you're saying it to the court right now, I asked for the key back, makes it sound like it was a very simple, calm request.
Right.
Is that exactly the way it happened or was it a different demeanor?
Yes, I asked for it calmly. He said that he doesn't stop by unwanted or like without letting me know first, and then he asked me, why do I need it? I did become upset, told him that I don't need to explain myself.
But to be clear, Ms. Levana, this was his apartment, correct?
Yes,
In other words, the lease was in his name.
yes,
And so he was ultimately responsible for the condition of the apartment
right,
and to return it in good order.
yes,
So him having the key, you weren't really in a position to demand that he give it back to you, correct?
Sustained.
But, and it got worse from there. Is that fair to say?
yes.
Okay, now, you guys weren't by yourself at that time, right?
Right.
Who was there?
My 11-year-old daughter.
Okay, and your 11-year-old daughter has seen you and David fight before, correct?
Not physically, no.
Okay. She's heard the arguments.
Yes,
And on this particular occasion, she did witness, correct?
yes,
So if she would have been made available to law enforcement or to the state, they could get an eyewitness's version of what took place,
right,
who the aggressor was, who did what.
right.
Okay, but that hasn't been done. Or I'll ask another question.
Sustained.
Have you advised the state that you had an eyewitness who could corroborate your version of the events?
No.
Do they even know that?
If
That
it's
she,
in the statement that she was there, yes.
okay. But when the various times that you come down here to talk to the state, you guys have not shared that information with her.
Or, I'm sorry.
Have you shared with the state that your daughter witnessed the events?
Object to ask and answer.
That'll be overruled. You can answer it.
Could you ask that again?
Have you let the state know that she was there and saw what happened?
I believe so. Yes,
Now, Ms. Levano, this isn't the first time you've made accusations against David, is that correct?
Overruled.
You've accused him of physically assaulting you in the past, correct?
not to the police, no.
Didn't we have a jury trial on an issue where you accused him of assaulting you, where you were a victim in the case? Sure.
Mhm.
Wasn't he found not guilty on one of the counts of his trial that we had, that he's currently on probation for? No?
No.
May I consult with my client real briefly,
Sure.
Judge? Okay, Judge, I'll move on.
Right, so were you able to find the answer to that last question? That it was or was not her?
I'm gonna move it on to something else.
Okay, so it wasn't her?
She was not the complainant in the case. Sometimes.
Okay,
sometimes
yeah, no.
people have more than one ex.
Oh, no, I understand. I just wanted to make sure there.
Sometimes many more.
Yes.
So let's talk about the issue with the phone, Ms. Levano. He actually bought that phone, correct?
No,
He didn't claim that he owned it?
No.
That wasn't part of the argument that, you know, he could take it because it was his and y'all fought over the phone for that reason? Okay. So, Ms. Levano, let's go back to where we started this questioning. We never got to the reason why you didn't want to testify in court today. Are you concerned that there's things that you told the police on the dating question that are not true?
No.
Are you concerned that he's going to be subject to going to prison over false statements you made to the police. Or misleading statements to the police. Is that part of the reason why you didn't want to testify, is that you didn't want to be put in a position of having to say things today that may or may not match what you've said in the past?
Sustained.
I think it's cross-examination, Judge, but I'll move on.
No, I mean, he's saying it's been asked and answered. So that's the objection I'm sustaining, but you can ask more questions.
On the whole, Ms. Lubano, isn't it fair to describe your relationship as one where both of you have been in the wrong in terms of how you treated the other person on occasions?
Yes.
Up to and including being physical with the other person. And in a similar instance like that is what happened in October of this year.
Yeah.
And so you don't want him to be punished for maybe what both of you might have been in the wrong of doing that day. Is that fair?
Overruled.
Yes.
You started out by telling the state that for the most part, your relationship with David has been okay.
Yes.
You still stand by that?
Yes.
You believe that if he were to continue on probation, that you and he could manage how your child was shared between the two of you without having to maybe be in the same place at the same time?
Yes.
That's what the relevance from.
That'll be overruled.
Has there been a protective order issued in this case? Is that, and he agreed to that, is that right?
I'm not sure.
Okay, well, okay. But is it fair to say that there's blame to go spread around between yourself and him for what happened in October?
Sustained.
I'll ask you another question, Mr. Water. You said that on a couple of occasions he grabbed you. Isn't it fair to say that he's grabbing you as you're being physically trying to strike him? Objection,
Overruled.
He was defending himself.
like he's grabbing you and you're swinging at him. That's my question.
No.
So you never attempted to strike him in any form or fashion. Okay, and you were totally defenseless the entire time and did nothing in terms of participating in a fight. I'll pass the witness, Judge.
All right, thank you. Okay. Sure.
Do you see the person in the corner that did this to you?
Yes.
Could you please point him out, describe him by an article of clothing that is wearing?
Brown.
Do you recall meeting with the police after this incident took place?
Yes.
Do you recall having photographs taken of you back then?
Yes.
Yes.
I'm handing you what has been pretty much exhibit 1, 2, and 3 for identification purposes. I'm going to hand these to you. Can you please hold them and tell me what you see in this one as much as exhibit number 1?
Picture of myself.
Good. Let's move on to number 2. What do you see in this picture, Ms. Obama?
Marks on my neck.
Let's move on to number 3. What is in that picture?
Correct.
Okay. Ms. Obama, these pictures that you just saw, they were made the same day as this incident took place? Are they a fair and accurate representation of how you appeared on this day? To your knowledge, have these photographs in any way been altered? This time, your state officer evidence takes exhibits 1, 2, and 3, and I'll attend to defense for review.
No objection to number 1, Judge, and I'd like to take her on board item number 2 and 3.
All right. State's exhibit number 1 is admitted.
Now, Ms. Lubana, in regards to picture number 2, why does that look like that, you know, in terms of the darkness of the picture?
The lights were turned off.
Okay, is that the same case in number 3?
Yes.
Okay, so this is not, this is a special form of photography or science that allows them to do this kind of thing, is that right? If you know.
Open for knowledge, Your Honor.
Well, that's my whole point, Jim.
Do
She
you
doesn't
know? Let me see states exhibits 2 and 3, please.
That I would suggest she's not able to sponsor these because she doesn't know what these are showing and what they mean. She's
All
never
right.
seen them before.
The defense's objection to states 2 and 3 will be sustained. States exhibit number 1 will be admitted. Any other questions for this witness state? Any other questions?
Yes, if I may ask for more questions about this petition. You testified earlier, Mr. Vano, that these pictures taken the day of the incident, correct? They were with police. Do you recall them having to take special pictures of the areas that are depicted?
Objection, leading the witness, Judge.
Sustained.
Do you recall them having to take pictures of the areas that are depicted in these pictures?
Yeah.
Do you recall if the lights were on and off at these particular times?
The lights were off.
Okay. Can you tell in these pictures that this is you and this is Alina?
Yes, the man in that.
Absolutely.
All right, defense's objection to states exhibits 2 and 3 will be sustained. Any other questions for this witness?
None from the state. No, Judge.
All right, you may be excused. Thank you. You can, well, no, just have a seat in the courtroom, please. Any other witnesses?
None from the state.
Defense, any witnesses?
Richard Williams, Judge.
All right, Mr. Duenas. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you're gonna need to speak up so I can hear and the court reporter can hear. You can lower your hand, state your name for the record. All right, defense, you may proceed.
Mr. Duenas, do you recall the incident in October with Ms. Levana who just left? And the two, do you agree with her that the two of you were together in a living together relationship for 4 years or more? And you have a child together? Okay. In what was your child's age at the time? Yeah, more or less, yeah. And how long have the two of you been living apart? Okay. So you knew that she already was in a new relationship, correct?
Sustained.
Did you know whether or not she was in a new relationship? And had you ever informed her whether or not you had proceeded to a new relationship? Okay. So was there any leftover issues between the two of you, or were you at this point separate and apart permanently? What do you mean by she had issues? You need to speak up.
My daughter. She. Like a speculation.
All right, that'll be sustained. And I'm gonna need you to speak up because I can barely hear you. I know the court reporter is struggling. All right, the objection to speculation as to the thoughts and feelings of the complainant, that will be sustained.
Okay, so what was the reasoning for you to be there that day?
She asked me to call me while I was at work if I could pick up the baby. Share plans.
Okay, and did you agree to do that?
Yes, I was going to dinner with my partner.
Okay, and were you working that day? And so what time did you make plans to be there to pick her up? Okay, and so did you get to her apartment around roughly that hour? Okay, and what was her demeanor like or her behavior at the time when you first encountered her that night?
She was fine.
Okay, so everything is fine. Okay, and at some point did that change? And what caused that to happen? Go ahead, loud, Dave.
This baby was midnight, couldn't wake her up. She was tired and put her out. Couldn't come back to her mom. I was off the next day.
How did she respond to that?
She said she already made plans and I was already there for me to take her. And I told her that she was the one who had her mom when she was excited. I was very late. Says I was the girl in the money.
So you didn't leave her upstairs to sleep. You actually picked her up and we're gonna take her.
Yes.
What was your concern? Why did you not want to do that?
I've been home in 8 months, so she's not that comfortable with me again, so.
Objective speculation, Your Honor.
Overruled.
You can finish your answer.
She, not that comfortable, she has with it. She cries and. So I didn't want that to happen.
Okay. And did you express that to her?
Yes, so. Tell her that she replied that she needs to get used to deciding to take her.
Okay. And at some point, did the tone of voice between you or her change? Okay, and then what proceeded to happen next?
And. That I, whatever I want, and.
Objective to hearsay, Your Honor.
Overruled.
So she's cursing at you, she's upset with you, and what happens next?
She, told me about money, she was showing money and how much spending it with my son, like giving her money to her apartment and helping her out.
Okay. So even though the two of you had separated, she's still living in an apartment that you're financially obligated to pay, is that right?
Objective leading, Your Honor.
Overruled.
But so all these things start coming out from her complaints, suggestions, comments, whatever you want to call them. After you told her you were gonna leave the baby.
Objective leading and relevance.
Overruled.
You tell the judge, David, tell me what happens after you tell her that you don't want to take her in that condition she was in at the time.
Wow. Not giving enough time for the baby, helping out. That's it. It's that part of. She left me, so that made her mad. We just continued to argue back and forth on the kids. She was in a car with them.
Okay, so what did she do next?
Home.
Okay, she grabbed your phone? Okay. So why was she grabbing your phone if you know?
Objective speculation, Your Honor.
Overruled.
Has she ever taken that tactic with you in the past when you guys have argued? Okay. Now, I asked her the question about whether or not she'd ever been physical with you. What is your answer to that question? Okay. And so when I say that, describe for the judge the kinds of actions she's taken against you in the past.
And on my hair in front of the children and the fun of five people I had nothing like that. And
Now you say glass pan, describe it for the court.
that's
Okay, so it's like a dish that you would store food that's cooked in? Okay. Did it break? And what was the injury that it caused to you? And did you file a police report as a result of that? Okay. Is this the first time that she'd gotten to that extreme with you? So that was the last day that the two of y'all were together? Okay. Now, you heard the way she described the way that you were acting that day, correct? She characterized it as you charging at her. Did you do that?
We're fighting on the phones. We discussed this. We didn't charge her.
So it was strictly the two of you. Were you fighting over your phone or fighting over hers, or both?
Well, she had mine. Just trying to avoid.
Okay. So at any point other than trying to get your phone back or taking hers, did you put your hands on her? Okay. She talks about being cornered in the kitchen. Did the tussle or the back and forth over the phones move around the apartment?
I'm not charged for the phone. She would walk back and then try to get my phone. But we still go back and forth.
Okay. You heard me ask her about her 11-year-old. Where was she at this time?
Watching.
Well, when you say she's watching, where was she? So in the same room y'all were in? Would you say she was there the whole time? Are you on good terms with her?
Object is irrelevant, Your Honor.
Sustained.
To your knowledge, well, yeah, something else. Why did you leave, after this all kind of, I guess, calmed down?
She threw me my phone back to my little kid, and I broke it. The daughter started crying and called her during the break, and I grabbed my phone and left.
Now, the phone that you broke, was that your phone or, I mean, who owned the phone? Okay. So she was using it, but. Okay. You understand, that probably wasn't the best move. Okay. But did you throw it at her or strike her with it or anything like that?
My phone got left it here.
Okay. Now, since she's gotten this protective order, has she reached out to try to communicate with you?
Object is irrelevant, Your Honor.
Overruled.
Since the protective, well, let's go back. Did you agree to a protective order with her? And when did that happen? Okay, so sometime after October. And you agreed to it in the sense that you signed off on, is that right?
Yeah.
Now, even though you got that order, has she still tried to communicate to you directly or through another person?
Object is irrelevant.
Overruled.
Has she tried to get messages to you or to communicate with you, even though the protective order is in place? Does she contact your family? I'll pass away, Judge.
State.
Mr. Duenas, you have been a monthly toward Ms. Luano, correct?
I don't know what that word means.
I can't hear you. I'm sorry. Can you turn towards me?
I don't know what that word means.
You don't like her really anymore, do you?
I still love her. Mother of my daughter.
I can't hear you again. Could you?
I still love her. She's the mother of my daughter.
Well, you have anger towards her, right? You don't have any anger towards her at all. So you just left because you just wanted to leave, right? Because it was a happy situation for you to leave, right? You were happy in doing so. You weren't angry at all at her because of what you're saying she did to you, right?
From that day? From what day?
Okay, well, let me help you out then. You were testifying earlier with Ms. Martinez asking you questions that you don't live with her anymore, right? If you had moved out, right?
Yes, sir.
You were angry in doing so, right?
I was just sad that our family is broken, so I left. There's nothing I can do.
There was nothing at all you could do to try and make things better, right?
No,
You certainly couldn't act better on your end towards her, right?
because I moved, I made my decision to get away from her.
Okay. So because of that, and you having to now live somewhere else, this is an inconvenience for you then, right?
Oh,
Okay. You have to make arrangements with her whenever you want to see the child that you have in common then, right? No, you don't. So you just go whenever you want to over there?
Father, you said yes or no, and I don't argue.
Right, exactly. Those are arrangements that you're making with her to see the child, right?
Oh, yes.
Okay. So on this day, you had made an arrangement to go and see your child then, right?
She made an arrangement with me.
So you never reached out to her first?
She reached out to me.
She reached out to you, okay, so, but you still said, okay, I'm gonna go and see my daughter then, right?
Yes,
You went over there after work, as you testified earlier, right?
yes,
Okay, and when you got there, you went to go and see your daughter, right, who was upstairs sleeping?
yes,
Okay. And after that, you brought her downstairs, right?
yes,
Was she still asleep at that time?
yes.
All right. And then there was an argument that took place between you and Miss Lavanu, right, about a key to the apartment?
More things too, but yes.
Okay, well, that was one of the things you argued about, right?
Yes,
And you didn't want to give it to her because it's your apartment, right?
yes.
Because in your opinion, she doesn't have a right to have a key to the apartment that she lives in with her children, right?
Oh, well, she's moving out.
Well, at the time it wasn't though, right?
No,
Time it was active,
the lease was already expired and.
it was expired, so you were allowing her to live there after at least that expires. Is that what you're saying?
Yes, because she was moving out, she said.
Okay, so the apartment complex was aware that there's someone living in this apartment that's not on the lease.
Yes.
Okay, that's what you're saying. All right, so you get there that day. And you guys have this argument about that, that makes you angry, right?
No.
You didn't get angry about anything. Okay, so you're calm, having a conversation with her the entire time.
About the key, I wasn't upset.
Okay, but okay, other things then upset you then, right?
But
Yeah, you got upset, so you went at her, right?
no,
You never went at her? You never put your hands on her neck? Never choked her at all? Never lifted her off the ground with your arms around her and on her neck?
not that strong to lift the ground now, I would never.
Okay, so you never did that either. That's not true.
No, it's not true.
Okay, but so the only thing you did is grab her phone and smash it then, right?
I said, you grab my phone.
After she grabbed yours. So you grabbed yours in retaliation and you smashed it because you felt like it's your phone and you own it and you can do whatever you want, right?
Yes,
Okay. So, and this was done in front of her children there, right?
yes.
You felt like that was appropriate behavior to act like that in front of two children?
No.
You still did it anyway though, right?
Yes.
Okay. One of them being yours, right? Okay, so it didn't matter to you at that point how that might affect them, right? You were just too angry to care about that. You were, okay, so you just snapped the phone in a calm, nice manner, right?
Father's very trying to get out.
Wanted to get out, so you did that. You just got out there and you left your child there, right?
Yes.
At that point, you didn't care, you just wanted to get out. Okay. And you're obviously aware that you're on probation for a case that you had gone to jury trial on, right?
Yes,
And is it important to you to keep up with the terms of those probation?
yes,
Because you want to be on probation.
yes,
You want to do well on probation.
yes.
And you felt like this was the appropriate way to show that you're doing well on probation?
That's why I wanted to leave. That day, that's why I was trying to leave.
You were trying to leave, even despite all this stuff, you were wanting to leave because of your probation.
Because she kept saying she was gonna come leave.
Okay. Did you ever call the police that day to tell them your version of what happened?
No, because I didn't hurt her, so I wasn't aware of anything. I just thought it was, I didn't hurt her, she didn't hurt me, I just thought we would just talk to each other, just blow it over and she'd apologize, because she always does, she'll apologize. And we try to co-parent, that's all I thought was gonna happen, I didn't hurt her, I didn't do anything, so I didn't think of anything was gonna happen.
All right, any other questions?
From the state.
Any follow-up questions?
Not on the allegations on number one, Judge. No.
All right. Any other witnesses from either side?
None from the state.
Judge, I would have questions for probation, but not as to the truth or not untruth of the allegations of number one, just depending on if that's necessary. But I'm assuming we're gonna ask,
No, what questions you
well,
have?
just like how he's doing on probation, whether he's, all the things he's supposed to be doing, things like that, but.
All right.
All the numbers, Judge.
That's fine.
Yes.
Yes.
Williams?
All right, you're still on, defense tells me they have some questions. They just want to know how Mr. Joynes was doing on probation other than with this allegation.
Your Honor, he was doing fine, he was showing up on time for his virtual visits. Unfortunately, he testified for cocaine and cardiac effects. Other than that, he showed up on time.
Well, but he's done more than that, to be fair, right? He's completed classes, correct? Matter of fact, you have a listing of all the things that he's completed. Tell the judge all the things he's completed on probation.
So he's completed matters intervention, GPS. He provided a DNA sample on his parenting class.
What about community service?
Yes, he's completed for me.
Well, how's he done on those payments?
So he made payments. He does have a balance of $3,712.
Okay, but that includes probation fees that are due in the future, correct?
Correct.
How much is he actually paid towards probation?
So he's actually paid $244.
Okay. Now, isn't it true that you advised him that because of all the things he's completed, and if he got current with his probation fees, that he might be eligible for early termination? Reject his term, Mr. Ryan.
Overruled.
You didn't have that conversation with him? Okay. Who did he have before you? Or did he have somebody before you? Is better.
Yes.
Okay, so you've only been on the case just a couple
2
months. Okay. That's what it should. No
All right.
questions, Ron.
Thank you so much. All right. With regards to violation of condition number 2, the court is finding it not true. The court will note for the record that the probation officer did state that Mr. Duenas, I believe, tested positive, but the court is not considering that because I know that the defense was bringing the witness strictly for the purposes of how he was doing on probation and with regards to whether or not he tested positive for cocaine. Lab reports would need to be presented and the person, whoever is responsible for doing the testing, would need to come in and testify. So that'll be found not true. With regards to violation of condition number 1, the court is finding violation of condition number 1 true. Is there a request from the state?
Mr. Honor, that request is to revoke the defendant's probation and sentence him to 2 years in prison.
All right, defense.
Well, clearly, Judge, we're not in agreement with that. And now that you've heard the testimony in the case, you can see why we're anxious to take this case before a jury and get a determination after a full and complete trial of all of the issues with all of the witnesses and other evidence that's relevant and admissible in court. Due to his performance on probation, Judge, and his obligation in terms of support, his voluntary acquiescence to the protective order, we'd ask the court to employ one of the many sanctions that the court has available and to keep him on his probation. If nothing else, at least until we resolve that new charge. The state's gonna have another shot at him. In that case, they can ask for a full range of punishment, and they won't be limited to the 2 years that the court has in this situation. I think Ms. Levana was honest when she said that it's a two-way street. And she was being very kind to herself about that. When you smash a pot over somebody's head and embed glass into their shoulder, that suggests you the type of person that she really is. And why she admittedly was reluctant to come and testify in court because there's things that she's done and contributed to this situation happening in October that she's not proud of either. I think they both are embarrassed that all this had to come to light in public, and they both could have done better and handled the situation than and so, Judge, in light of everything, rest in the court not to revoke his probation and to consider other alternatives.
All right, and counsel, have you completed the trial court certification?
I have not, Judge. I've been kind of busy last.
Oh, if you all will complete that for me, please.
By signing the because if you understand that you have limited rights to appeal.
All right. The court is going to grant the state's motion to revoke. The court will sentence you to 2 years in the prison, giving credit for any time served. There's an affirmative finding of deadly weapon. There's to be no contact with Danessa Duenas, Christian Rodriguez, and Charles Waterson. And that's from the previous conditions that were given when you were placed on community supervision by the jury. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? You do have a right to appeal. That right to appeal is as it relates to the allegation in the motion, not the fact that you're in community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition, okay? All right, good luck to you, sir. Della O. And anybody else who's ready with their pleas, can you start putting them here, please?
Yes, it is.
I have the two, but,
And I have two more I'm preparing right now.
all right. How long is this gonna take? All right. 1 second. Are you all available tomorrow?
Well, we do have availability tomorrow, what time is the working?
Norma, what time? Okay. So mental health graduation starts at 9 a.m. I just have to run down there and do a couple of things. So you're saying it'll take an hour? All right.
These limitations based on our arguments, but yeah, we've got.
Well, I will tell you, if it's at 11 and it'll take an hour, we'll be finished before lunch. Well, approximately lunchtime.
I've got it. For tomorrow. Right.
No,
Yes, we're.
All right, who are the parties on Eddie Sullivan?
Judge, that's me. They're bringing it back out right now. I also have that probation paper Jeffrey as well. You asked me to reapproach on.
Jeffrey, just give me 1 second. All right, who's here on, they're not bringing him out yet, is he?
Eddie Sullivan?
Yes.
Yes, she's right here.
Oh, no, we're not Eddie Sullivan. It's, oh, let me see. I'm so sorry. Yes, Eddie Sullivan. Yes. Great, thank you. Thank you. Hello, Mr. Sullivan. All right. You're right. All right. All right, the court is calling 2018 CR 8528 State versus Eddie Leroy Sullivan III. Can I have parties announced?
Lauren Espinoza for the state.
And Jonathan Alvarado for the defense.
And are you Mr. Sullivan? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Eddie Leroy Sullivan III who was placed on deferred adjudication in 2018 CR 8528 for the offense of obstruction or retaliation on June 11, 2019 for a period of 5 years? Is that you? All right, state.
Violated condition number 5 in Bexar County, Texas. The defendant Eddie Leroy Sullivan III did then and there fail to report to the supervision officer as directed for the months of September and October 2024 in violation of condition number 5.
How do you plead to that? True or not true?
State will waive the remaining violated condition alleged.
Any objections?
No objections.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. And counsel, it's my understanding that your client was found competent, correct?
Yes, Judge, and I was reappointed onto the case after that evaluation was ordered, but I had reviewed the order and was found competent.
All right, is there a proposed agreement?
There is, Your Honor, the proposed agreement is to grant state's motion to sentence Mr. Sullivan to 2 years in detention.
Okay.
And there is also, Judge, a misdemeanor case he is going to plea on that case.
Are you asking the court to follow that agreement? Are you waiving your right to appeal? All right, why were you not successful on probation?
My grandparents, made poor decisions.
All right, and that violation of condition number 5, that is in count 1 as well as count 2, correct? All right, so the court will follow your agreement. And are you waiving your right to appeal? All right, the court will follow your agreement, find you guilty, and revoke in counts 1 and counts 2, sentence you to 2 years in counts 1 and count 2. Give you credit for any time served. There's a $1,500 fine, time and money to run concurrent. There's to be no contact with Michael Ebrom, EBROM, and M. Bennett. Counts 1 and counts 2 are to run concurrently. And our request, the therapeutic community, it doesn't increase the time that you've been in custody, but it will help with any addictions you may have. Is there anything else with regards to sentencing?
Nothing else.
Not for the defense.
Here. Yeah, so did you review, you're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So, Mr. Sullivan, when you're released from custody, if for some reason you cannot find a place that can help you maintain your sobriety, if I'm still here, you come back here and I'll make sure that I pick up the phone to call someone who can help you with transitional housing. But you gotta want it. All right? All right, good luck to you, sir. All right, who's here on Nicholas Salazar? Nicholas Salazar. Who's the attorney for Nicholas Salazar?
It's Michael.
I believe he stepped out for a cigarette, Judge.
Okay.
Seems like I read that, yeah.
Judge, if we need to, swear in the interpreter, David's phone died. The interpreter's still online. Can you do it in front of me?
Oh, sure we can.
I was thinking long and it just died.
All right, who's the interpreter?
She should be up there.
Rita.
Okay. And have you all,
Paperwork is ready.
who is your client? What's your client's name?
Lupana Gold.
I don't have the paperwork.
She has to swear him in.
All right.
That's what we're gonna do.
Ah, so you can't swear him in the Zoom?
No, because he's
Okay.
here.
All right, let's bring him up so she can swear him in. And then after that, I'll take Martinez, Ruben Martinez.
Yes, we need them to be. Yeah. Thank you.
All right, and Chris Ramos, what's happening with your case?
On Ruben Martinez, it's a plea recommendation for community supervision.
We're silent on deferred, he's in jail, no priors.
All right, and are you gonna waive PSI?
We will, Judge.
All right, if you'll make sure Ms. Abrams knows what your plea is, and we'll take it up.
That's gonna be on Martinez.
Okay.
Okay.
All right, to the interpreter who's on Zoom, if you can unmute, please.
Hello, Judge.
Hello. The clerk is going to swear in the defendant. So if you can just interpret everything that's being said for us, please.
Yes, Judge. I do.
All right, you may proceed. Oh, no. You're gonna need to speak up.
Yes, I can hear, please. خیل هستی چې کوروره او وایه چې هر څه وایم درته قاضي وایي حقیقت. He wants to say like I raise my hand. I want to. What should I say?
No. Could someone speak into the microphone so she can hear, please?
Yes, ma'am. I need to swear him in. Can you please repeat his name? I believe it's Abdul. I cannot pronounce his full name.
وروره وایي مازې لاس کته که مازې راته ووایه چې ستا مکمل نوم څه شی دی؟ عبدل پوهېږم خو تخلص دې نه پوهېږم. مکمل نوم دې راته ووایه وروره.
زما نوم عبدالغفور. Last name Onufial Worth.
Did you get it?
Yes, I did. Thank you. Mr. Gould, please raise your right hand. Do you solemnly affirm that the information that you have gone over in these documents is true and correct to your best knowledge?
وروره وایي دا هر ټول معلومات چې تا ته درکړل شوي دي او تا چې موږ ته راکړي دي خپل معلومات وایي تاسو قسم وخورئ چې دا هر څه تاسو ویلي دي هر څه صحیح دي د صحیح نه بغیر بل څه نشته.
هو دا هر څه ما صحیح ویلي دي. انګلیسي د پوهنې د پوهېږم نه په دغه هیمالیا راته ویل ما.
Yes, everything, all the information I have said, it's true. There is nothing without truth.
Mr. Gould, do you understand by signing the waiver that you gave up your right for having a jury trial, sir?
وروره وایي دغه ورقه چې ما درته وویل او تاسو امضا وکړله وایي په هغې باندې پوه شوې که نه؟
او پوه شوم ډېر ورته راته وویلې.
Yes, I understand. And there was like too many papers I have signed and all I understood.
Thank you. I'm gonna verify your signature now.
اوس زه درته ستا امضا ښیم.
This is the plea paperwork that you went over with your attorney.
دغه اسنادونه دي د هماغه ورقې دي چې وکیل سره تا مخ ته ویوړه.
و
Yes.
Yes, judge.
Is this your signature here, sir?
دا ستا امضا ده وروره، تا امضا کړې ورته.
و دا زما امضا ده.
Yes, that is my signature.
Thank you. This is the actual plea bargain paperwork, sir, that you went over. Does everything look true and correct? And are these your two signatures here, sir?
دا هر څه چې درته معلومات ویل شو هر څه رښتیا دي او ته پې پوه شوې یې او دا ستا دوه امضاګانې دي چې تا خپله کړي. آیا دا صحیح ده؟
او دا صحیح دي. په د انګلیسي باندې خو زه نه پوهېږم. د امضا زما دی. ما ستر زوی لري. امضا زما ده او
Yeah, so the signatures are mine because right now there's in English. I can't read it.
I understand. Thank you.
ما
But he-
پوه شوم وروره مننه.
He did go over everything with an interpreter for the plea bargain agreement, ma'am.
Yes, Jack. Yes, ma'am.
Thank you. This is the waiver that you gave up your right for having a jury trial. Did you go over this in the language that you understood?
وروره وایي دغه ټول هغه وکیل چې تا ته درته کوم خبرې درته وکړلې او ما تا ته تشریح کړله وایي هغه څه دي چې درته ویل شوي دي هغه صحیح ده پې پوه شوې یې؟
او زه په پوه شوی یم هغه صحیح ده.
Yes, I understood.
Thank you.
مننه.
Is this your signature here on this waiver?
دغه وګوره دا هم ستا امضا ده وروره.
او دا زما امضا ده.
Yes, that's my signature.
Thank you. And there's one more right here, sir. Is this your signature?
دلته یو بله وثه کړم دا وګوره دا هم ستا امضا ده.
او دا زما امضا ده.
Yes, that's my
Thank
signature.
you very much, sir. We can continue. Thank you, Judge.
مننه کوم وروره.
Oh, you can lower your hand, sir.
لاس دې ښکته کړه وروره.
Norma, what page is he on?
1 second, Judge. He's on page 10. 4 down.
All right, the court is calling 2025 CR 011985 State versus Abdul Ghaffar Khan Kunifa Gul.
Where is this?
وروره وایي تاسو نوم اوس غږ کوي چې 25 کال CR 011985 عبدالغفور خان.
All right, could I have parties announced for the record for the state?
اوس یو نفر راځي ریکارډ کوي د سټیټ ته طرف نه.
Lord Espinoza for the state.
For the defense?
David Rodriguez for the defendant.
All right, and he just stated James Rodriguez for the defendant. Everybody's going to have to speak up so she can hear.
David.
I'm sorry, David Rodriguez for the defendant. I need everyone to keep their voice up.
دا وکیل چې دی دا خو ته پیژنې دا ډیوډ دا ستا وکیل دی ښه مدافع وکیل.
All
Okay.
right, and we have an interpreter by Zoom. To the interpreter, could you raise your hand for the court, your right hand?
Yes, Judge, I do.
Do you solemnly swear and affirm you will faithfully translate from English into Mr. Gould's language and from Mr. Gould's language into English?
Yes, Judge, I do.
All right, you can lower your hand. And can you tell the court what is Mr. Gould's language?
It is Pashto.
All right, thank you.
Thank you, Judge.
All right, Mr. Gould, all of the documents that I'm going to review with you are in English. Were those documents explained to you in your language?
عبدل وروره وایي د قاضي وایي چې زه دا ټول اسنادونه چې دی یو ځل بیا د مرور دپاره په انګلیسي درته وایم او زه به درته ترجمه کوم وروره صحیح شو؟
صحیح شو.
Okay.
What's the answer? I need a yes or no.
وایي چې ماته جواب راکړه چې هو راته ویل شوي دي او نه راته نه دي ویل شوي.
هو
Yes.
Were the documents explained to you in your language?
وروره وایي کوم اسنادونه چې درته تشریح شوي دي د انګلیسي څخه پښتو ته آیا تاسو ته ترجمه شوي دي که نه؟
که ترجمه شوي دي خو د اسنادونو مقصد دومره وخت نه ټوله ترجمه دي.
Yes, all documents were translated.
All right. Did you, counsel, did you receive all the discovery and review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the application for deferred adjudication with your attorney? Did you understand it?
وایي کوم خبرې اترې چې کوم جزئیات چې وکیل درته وړاندې کړل خپل وکیل په خبرو هر څه باندې پوه شوې؟ Yes, Judge.
Did you review the true bill of indictment with your attorney? Did you understand it?
خپل وکیل سره چې د هر څه په باره کې در سره خبرې وکړل هغه باندې پوه شوې؟ Yes, Judge, I understood.
Counsel, do you waive the reading of the indictment?
I do, Judge.
I need the interpreter to repeat that, please.
Yes,
Counsel,
Judge.
counsel, do you waive the reading of the indictment?
وایي آیا ته دغه جزئیات چې درته وړاندې شو دوی ته دوباره درته تاسو تشریح کوي صحیح ده؟ Okay,
No, no, no. Defense attorney, do you waive the reading of the indictment?
I do, Your Honor.
All right, and if you could repeat that to the interpreter, please.
وکیل ته وایي چې د هر څه دې ورسره خبرې اترې دي کړي مرور کړي دي د دوباره هغه وکیل ویل چې و ما کړی.
State, are you proceeding on the indictment as presented?
او هغه بل چې دی هغه بله ښځه چې ده هغوی هم وایي هغې ته یې وویله چې مثلا تا هم د دوی سره برخه اخیستې ده دوی ورته وایي چې هو.
Yes, Your Honor.
او وایي.
Right. Did you review the court admonishments with your attorney, Mr. Gould?
تا هم وایي خپل دغه ټول جزئیات خپل وکیل سره هر څه خبرې اترې دي وکړې ورسره که نه د وکیل سره؟
ما ټولې خبرې ورسره وکړې.
Yes.
Right. You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
وروره وایي ته په دې پوه شوې چې مثلا ستا په هغه شی کې چې تا پیدا کړی و هغه د 1 ګرام څخه مثلا کم تقریبا 1 ګرام اندازه مواد مخدره ټوکي وي چې هغې دا چې دی فلاني یو جرم دی او همدارنګه د دې باعث کیدای شي دا جرم چې تا د مثلا 100 نه تر 2 کالو پورې تا جیل ته ولیږي او همدارنګه $10,000 پورې جریمه در باندې راشي.
او دغه خو ما پیدا کړی و نور ما لیدلی نه دی چې 1 ګرام و څومره و خو ډبه یې ما راواخیستو پیدا کړو زه ځان نه مجرم ښیم نه ځان نه زه صحیح ښیم.
Yes, that is correct, but I have found that, but I didn't know how many gram were in there, what was inside that box. I just found it.
All right. Do you want a jury trial?
وروره وایي ته غواړې چې هغه وکیل چې درته ویله ما خبرې باندې کومه عریضه کوې که نه؟
او وکیل چې څه راته وویله خبرې زه منم.
I talked with the attorney and I agree with him.
So do you want a jury trial or do you want to enter into this plea bargain agreement?
لکه ته غواړې چې د هماغه شیان چې وکیل درته ویل ته په هغې باندې راضي یې که ته غواړې چې بله عریضه وکړې؟
نه زه په هغه باندې راضي یم وکیل چې ته راته ووایي.
I follow my attorney's agreement.
All right. Do you understand you have a right to jury trial for your attorney or you to cross-examine any witnesses the state would call in the right to remain silent?
وروره ته په دې باندې پوهېږې چې دا ستا حق دی چې مثلا وکیل یا کوم بل شاهد چې راشي او مثلا معلومات تحقیقات وکړي چې تا رښتیا هغه کار کړی دا ستا حق دی ته غواړې چې هغه په خلاف وجنګېږي یا نه وایي څه چې وکیل درته ویلی چې هغه مخته وړې.
زه خو څه چې وکیل راته وایي هغه زه منم نه راته زه خو ولا ښه پوهېږم.
I understand and whatever my attorney say the instruction, I will follow that. And other than that, I don't know.
All right. If the court grants your application for deferred adjudication, if you're revoked, the court can sentence you up to 2 years in the state jail facility. Did you understand?
وای کچیر محکمه مثلا دغه چې شیخ خپل هغه اعلان کې چې دغه رضایت مندي ونه مني یا ته په دې پوهیږې چې خدای نخواسته تا 2 کاله جیل ته لیږي.
زه به څه ووایم دی قانون وي هغه قانون زه عملي کوم.
Yes, so whatever the law says, I follow that.
My question is, did you understand that?
وای مطلب ما پوښتنه ده چې ته په دې پوهیږې فقط هو ورته ووایه.
Oh,
Yes, Judge.
All right. Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
کله هم تاسې څوک ځورولی یاست دغه کړی یاست چې مثلا تاسو ته اختاریه درکړې یا بل کوم ځورونې در سره کړي؟
نه.
No, Judge.
Has anyone promised you anything other than the plea?
لکه بل څوک د پلی نه بغیر لکه وایي چې عریضه نه بغیر وایي تاسو ته کله هم پیشنهاد کړي د پیسو که نه؟
نه.
No, Judge.
Are you satisfied with the way you've been represented?
هر څه چې ته وړاندې کوې موږ ته دې وړاندې کړي دي په دې باندې ته راضي یې؟
او په دې باندې زه راضي یم خو دغه یوه خبره چې د ډبای ما موندلی وه زه خو دا نه شوم پوهی چې 1 ګرام کې دي څومره کې دي خو دا مو موندلی وو مقصد دا کې زه نه ځان مجرم ښیم نه ځان صحیح ښیم.
Yes, Judge, I understand. And the other thing I want to mention that the box that I have found, and I didn't know, I don't know like it was 1 gram or how much, but I just found it. And then other than that, I want to add that I not feel guilty or not feel not guilty, but I feel no contest.
That's not my question. I need you to listen to the questions that I'm asking of you. Do you understand?
وای دا زما پوښتنه نه ده وای زه غواړم ته په دې پوه شې چې کوم پوښتنه زه درنه کوم هغه جواب ورکړه ته په دې پوهیږې؟
په څه شو باندې؟
Okay, Judge, can you repeat it?
Inshallah, do you understand?
ته پوهیږې وروره؟
Oh.
Yes, Judge.
All right. If you're not a U.S. citizen, by entering into this plea, you can be deported, denied re-entry, and naturalization. Do you understand?
وای ته که چېرته وایې مثلا ته امریکایي پاسپورټ دې نه اخیستې اوسه پورې یو سټیزن شوی نه یې نو په تا به کیدی شي وشړل شي د دې ځای نه او یا هم ستا هغه کومه ورځ باندې چې ته اپلای کوې هغه ورځ باندې وایي تا د دې ځای نه لرې کړي هغه دغه کینسل کړي درته او همدارنګه ته به د دې ځای نه وشړل شي ته په دې باندې وایي پوهېږې که نه؟
زه په دې باندې پوهېږم زه چې کته پاسپورټ ته اپلای کوم ماته ویل شوي چې انګلیسي دې نه وي زه کوشش کوم چې انګلیسي مې لږه لږه زده کړې زه کوشش کوم چې انګلیسي زده کړم دغه یو 2 کالو کې بیا اپلای ورته وکړم.
Yes, Judge, I understand this all, but I'm trying to get my passport as soon as I can because for the passport I have to have learn English to speak more English. So for that I need time to learn English. Then I can go ahead and apply for citizenship.
Okay, I want you to listen to what I'm saying. And I want you to answer the question that I'm asking of you and nothing else at this point in time. Do you understand?
وروره قاضي چې دی تا ته وایي کومه پوښتنه چې درنه کومه همغه جواب راکړه اضافي خبرې پکې مه کوه فقط دومره درته وایم چې څه درته وایم جواب یې راکړه اضافي خبرې ته پوهېږې په دې باندې پوه شوې؟
صحیح شوه پوه شوم.
Got it, Judge.
All right. If you're not a U.S. citizen, by entering into this plea bargain agreement, you will be deported. Do you understand?
که چیرې وایي ته یو اس سټیزن یا د امریکا شهروندي دې نه ترلاسه کړې که چیرې ته مثلا همدا بیا عریضه وکړې او ته نه یې بیا کیدی شي ته د دې ځای نه وشړل شي ته په دې پوه شوې که نه؟
پوه شوم.
Got it.
You will be denied naturalization. Do you understand?
او که چیرې ته مثلا ولاړ شې هلته نیچرلایزیشن هغه ورقه چې ستا نوم شان درکړي د پاسپورټ په ورځ باندې هغه هم به رد شي ته په دې پوه شوې؟
پوه شوم.
Yes, Judge.
You will not be allowed back in the United States. Do you understand?
ته به بیرته واپس امریکې ته ونه راوړل شي. ته په دې پوه شوې؟
پوه شوم.
Got it, Judge.
Counsel, have you been able to communicate with your client through the interpreter?
وای تا وکیل سره خبرې وکړې د ترجمان سره وکیل ته وای تا خپل تا سره خبرې کړې د ترجمان سره کنه؟
ما سره خبرې کړې.
Now it's for your attorney to answer.
دا وکیل خبر جواب ورکړي ته غلیک شه.
Yes, I have, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him? I need you to interpret that.
وکیل نه پوښتنه وکړه وکیل ورته چې هو ما خپل خبرې اترې ورسره کړې دي او بیا وکیل نه پوښتنه وکړه چې آیا تاسو د تاخې د په دې باندې پوه شوی دی چې دا کیس تا په خلاف دی تا د سکار کړی دی او اوس هغه وکیل جواب ورکړي.
I believe he does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
وکیل ویل چې هو کړی دی او بیا ترې نه پوښتنه وکړه چې دا قانوني خبرې ورسره کړې دي په قانون باندې پوه کړې که نه یې پوه کړې اوس وکیل جواب ورکوي.
I do, Judge.
Court will find.
Sorry.
I'm sorry, go ahead.
وکیل ویل چې و ما کړی.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial.
وایي چې محکمه کې مثلا اضافه خبرې باید ونه شي کوم کسان چې والنټیر رضاکارانه کارم باید وکړي دا هم درته ویلي وو اوس وکیل جواب ورکوي.
All right. According to your plea bargain agreement, the state is recommending deferred adjudication and there's an $800 fine. Did you understand?
وروره اوس ته جواب ورکړي چې مثلا د ټولو شیانو په مطابق باندې وایي سټیټ چې دی دا تصمیم ونیول چې دا د $800 به ته جریمه ورکوي په دې باندې پوه شوې؟
پوه شوم. صحیح.
Yes, understand, Judge.
To both counsels, is that the plea?
Yes, Your Honor.
دواړو ته وایي آیا دا عریضه صحیح ده؟ دواړه ویل چې هو صحیح ده.
By signing this waiver of appeal paragraph twice, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
د دواړو طرف نه په آخر کې دا ورقه امضا شوه چې مثلا د کوم عریضه چې تا کړې وه دا ستا هر څه د هغې سړي سره تا خبرې کړې دي او په دې باندې ته هر څه باندې پوه شوې. صحیح ده؟
صحیح ده پوه شوم.
Yes, understand, Judge.
Counsel, have there been any such motions?
No, Your Honor.
او قاضي پوښتنه وکړه چې دا کوم احساساتي خو نه دی هغه ورته ویل چې نه دی.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, 120 hours of community service, the DOEP course, and random UAs. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
وروره د ایالت یا د سټیټ څخه دوی وایي دا تا نه وړاندیز کړی دی چې ته به 100 ورځې ته به مثلا کومکي کار کوې رضاکارانه کار کوې پیسې به نه اخلې او همدارنګه د DOP یو صنف دی چې هغه باید واخلې او دا چې دی ټول د سټیټ د خوا څخه تا ته وړاندیز شوی دی چې محکمه چې دی یا کوټ وایي په دې باندې څه ویل نه لري.
نه پوه شوم بس په دې باندې زه څه ویل نه لرم. صحیح.
Yes, Judge, I got it.
All right, then how do you plead? Guilty, not guilty, or no contest?
نو اوس په آخر کې تا نه پوښتنه کوي چې ته ځان ګناهګار احساسوې بې ګناه احساس کوې که هم هغه دریم چې تا ته هغه سړی ویلی و نو کانټیسټ.
زه ځان نه بې ګناه حسابوم نه ځان ګناهګار حسابوم د کیس په مقابل کې.
So not guilty, not you chose the no contest option.
All right, state any evidence.
Come شواهد.
Yes, Your Honor. State offers States Exhibit 1 and all attachments.
محکمه چې د سټیټ چې دی دوی ته نه دا وړاندیز کوي چې درته څه وویل غواړي اوس درته وایي.
No objection, Your Honor.
اوس وکیل زر خبرې کوي.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it?
هغه کم ورقه چې در باندې وکیل امضا کړله وایي خبرې در سره وکړلې په هغه باندې پوه شوې.
پوه شو.
Yes, Judge, understood.
You have a right to jury trial, a right for your attorney to cross-examine witnesses, and the right to remain silent. Today, the state is going to be presenting evidence with just police reports and documents. Do you understand?
وایي ته په دې باندې پوه شې چې ته به ځان غلی نیسې که چیرې شواهد ستا په خلاف پیدا شو او په پولیس راپور ورته ورغله تر هغه وخته پورې ته به ځان غلی نیسې. ته په دې پوه شوې؟
پوه شو.
Yes, Judge, understood.
All right, the court will accept the court will accept into evidence state's exhibits. The court will find that the defendant has voluntarily stipulated to the testimony. The court has reviewed the same. The court will find that there's sufficient evidence to find you guilty and defer finding of guilt.
وایي محکمه به په آخر کې دا اعلان کوي چې مثلا د شواهدو په نظر کې نیول سي تر څو چې شواهد پیدا شي چې ستا په خلاف باندې محکمه به دا اعلان ورکوي په آخر کې چې مثلا یا به ته په شواهد نه وروسته یا به ته ګناهکار ثابتې یا به بې ګناه هغې نه هغه بیا وروسته خبره ده. Got it, understood, Judge.
Are we proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Only that I would urge the court to follow the plea bargain agreement.
You may repeat that.
قاضي پوښتنه وکړه چې ته څه ویل غواړې ستا خپل د دغه ستا په وړاندې باندې ستا په حساب باندې دی ورته ویل چې غواړم زما ستا په باره کې څه ویل غواړي دا خپله خبرې کوي.
All right. Do you have any children?
ماشومان لرې وروره؟
نه ماشومان زه نه لرم.
ماشومان sorry I couldn't hear. Can I ask you one more time?
Yes.
وروره ته بچي لرې؟
نه ما بچی نشته.
No, I don't have.
Court will sentence you to 2 years deferred adjudication, regular reporting by Zoom or in person. Regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, $800 fine. That will be probated.
Aurora?
Sorry, just 1 second. 120 hours of community service restitution and TAP evaluation out of custody. Follow TAP recommendations. You may repeat that.
قاضي وایي چې کنه وایي دلته چې دی وایي مثلا ته چې مثلا یا کار به کوې 15 ورځې یا مثلا ته د جیل څخه وتلو وخت کې غواړې چې ووځې 120 ورځې مثلا ته باید کومکي رضاکارانه کار وکړې خلکو سره چا سره هر بخش کې دي چې کوله او همدارنګه وایي چې $800 دغه جریمه به ورکړې.
Probation, is there anything else? Field visits 1 time per month until further notice.
وایي میاشتې کې یو ځلې باید تاسو وګورو. So per visit is monthly, sorry, Judge?
Field visits 1 time per month until further notice.
وایي چې یو میاشتې د میاشتې یو ځله به دوی تاسو سره ګوري. Okay, Judge.
Is there anything else you need from the court to be successful?
اورora وایي داسې څه نور غواړې د محکمې په وړاندې باندې چې څه ویل لرې؟
نه زه څه نه وایم.
No, thank you, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney, and did you sign it?
هغه ورقې چې درته امضا کړلې وایي هغه دې وویله مرور دې ورباندې وکړلې چې مثلا کوم حقونه ستا دي هغه ټول د وکیل سره که نه؟ Yes, Judge.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
او په دې خاطر چې ته د هغې ورقې شیان دې امضا کړي دي په دې باندې هر څه پوهېدلې یې نو وایي محکمه په دې کې تا سره غرض نه لري نو خپل عریضه دې خپل هغه وکیل سره به خبرې وکړي وایي په دې باندې خو ته پوهېږې که نه Yes, Judge.
All right, thank you. Interpret, if you'll stay on the line, Vashawn, what do we need to do with the interpretation?
Mr. Kimbrough is gonna log on to Zoom. If she could interpret for him, that would be great.
All right, thank you. All right, sir, just have a seat. We're going to make sure that probation goes over the conditions with you in your language.
وروره ویل کښېنه بیا هغه نظارت کوونکي یا څېړونکي افیسر راځي بیا هلته بیا ستا سره خبرې کوي زه به ترجماني درته کوم ته هلته کښېنه بېرته
All right, and
Thank you, Judge.
to the interpreter, oh, thank you so much. I think the language is beautiful. I'm going to work on my skills with it. I'm sending you to breakout room number 1, and someone from probation will meet you there.
I appreciate it, Judge. Thank you so much. I'm Joy.
Thank you. All right, Nicholas Salazar.
Moving judge, present.
Court is calling 2025 CR 012039 State versus Nicholas Salazar. Can I have the parties announced for the record for the state?
Lauren Espinoza for the state.
Defense?
Attorney John St. Hunters from Mr. Salazar.
Oh, off the record for a moment. But Sean, do you need this iPad? All right. Counsel, have you received all discovery? Did you review it with your client?
Your Honor, I believe so.
Court will find that the state is in compliance with discovery. Mr. Salazar, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Judge.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Judge.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented? Mr. Salazar, did you review court admonishments with your attorney? Did you understand it and sign it in both places?
Yes, Judge.
Did you understand by signing that? I'm sorry. Oh, no, that's yours.
Oh, sure.
That's okay. You reviewed the court admonishments?
Yes, Judge.
And did you sign it in all the appropriate places?
Yes, Judge.
You understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Judge.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Judge.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Salazar, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Judge.
Anyone promised you anything other than the plea?
Nothing.
Are you satisfied with the way you've been represented?
Yes, Judge.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Oh, sorry, is something going on back there?
Yeah. It's just,
Okay.
it's just media talking loud.
Not that we're calling anybody out.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Judge.
According to the plea, there's a $1,000 fine to be probated and the state recommends deferred. Did you understand that?
Yes, Judge.
Counsel, is that the plea?
That is the plea, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Judge.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Judge.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 120 hours of community service restitution, regular random UAs, and the DLEP course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Judge.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
I believe it is. Yeah, you're right.
State, any evidence?
Your Honor, state offer states exhibit 1 in all attachments.
Did you review the waiver? Oh, any objection?
No objection, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find that there's sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
I would ask that the court follow the plea agreement as negotiated between the state and my client.
All right. Do you have any children?
No, Your Honor.
Do you live with any minors in the household?
No, Your Honor.
Do you live by yourself?
I just have 2 dogs. It's just,
Oh, okay. What type of dogs?
husky and a Catahoula.
Oh, Husky in San Antonio. That makes for hot times. All right, the court will sentence you to 2 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, field visits 1 time per month for 6 months, 120 hours of community service restitution. Probation, you conduct an hour for every sober support meeting that is completed. There's $1,000 fine that will be probated. TAP evaluation. Out of custody, follow recommendations. If you're drug tested today, what would the results be?
Be clean, Your Honor.
All right. All right, probation, is there anything else?
No, Judge.
Is there anything else you need from the court to be successful?
No, Your Honor.
I'd just like to ask the court for one thing on the record, Your Honor. My client is a cook at a restaurant. His take-home pay is slightly less than $3,000. I would ask that the probation fees be set to the statutory minimum.
Oh, he'll have to provide proof of that, and then the court will make a consideration on that.
Thank you, Judge. I appreciate it.
All right, and where do you cook?
At a downtown restaurant, a steakhouse.
All right, and what is your specialty?
Well, I do the saute and prep,
Okay,
so a little bit of everything.
all right, awesome. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, make better choices. Good luck to you.
Thank you.
Thank you.
Judge, thank you for the court's time. I appreciate you, Your Honor.
All right, thank you.
Merry Christmas.
Merry Christmas to you too.
May I please be excused?
Yes. Ruben Martinez. And is there a plea on both?
Can I see your?
Court is calling 2025 CR 011513-02 and 2025 CR 011514, State versus Ruben Martinez. Can I have parties announced for the record?
Lauren Espinoza for the state.
Christopher Ramos for the defense.
And are you Mr. Martinez?
Yes.
And each of the cause numbers, did you review with your attorney the application for deferred adjudication? Did you understand it and sign it? Counsel, in each of the cause numbers, have you received all discovery and did you review it with your client?
Did, and we did review it.
In each cause number, the court will find that the state is in compliance with discovery. And each cause number, did you review the true bill of indictment with your attorney, Mr. Martinez, and did you understand? Counsel, do you waive the reading of the indictments in each cause number? In each cause number, state, are you proceeding on the indictment as presented? Mr. Martinez, in each cause number, did you review the court admonishments and defendants waivers with your attorney? Did you understand it and sign it in all the appropriate places? And cause number ending in 02, you're charged with obstruction or retaliation, and cause number ending in 14, you're charged with terroristic threat or impersonation of a public servant. Both of those are third-degree felonies. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
I did understand, Your Honor.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering these pleas, you were giving up those rights?
Here we are.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Here we are.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine in each cause number?
I do.
Counsel, in each cause number, has your client been able to provide you with any defenses?
Yeah.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Martinez, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the pleas?
No,
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, and re-entry. Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
yes, I did, Your Honor.
In each cause number, the cases are to run concurrently. The state is requesting that your fine be set at $1,200. The state is silent on your application for deferred adjudication. They're recommending community supervision. Did you understand that to be the plea in each of these case numbers?
Yes.
And in one cause number, they're taking in consideration 2025 CC 013418. Did you understand?
Yes, Your Honor.
Defense is at the plea?
Yes, Judge.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph in each of these cause numbers with your attorney? Did you understand it and sign it in both places?
I did.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I do, Honor.
Counsel, are there been any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 8 years. There be 120 hours of community service restitution, mental health evaluation, MRT, and parenting classes. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations? Then in each offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, in each cause number, do you have any evidence to support the defendant's plea?
Yes, Your Honor, state offered State's Exhibit 1 and all attachments in both.
No, Judge.
All right, state, have you had a chance to speak to any complainants?
Yes, Your Honor.
All right, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statement and police reports, but most importantly, there will be no live testimony? Did you understand?
Yeah.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Judge.
All right, anything you wish to say on behalf of your client?
Yes, Judge. Your court will notice that this offense took place around Father's Day. It was around Father's Day when the mother of his child, who was living in San Antonio, and my client was in El Paso. The mother of his child was denying him access to his son, was not allowing him to have contact with his son via phone. he, in a moment, an extreme moment of frustration, he called the non-emergency SAPD number and made a series of inappropriate criminal and hostile remarks on recording on 911. His goal was to get 911 and officers to his the location of his son. Unfortunately, he did not know the location of his son or the address of where he was staying. That is to the degree that the mom kept information from him. As he's making these calls, he became incredibly frustrated, which is no excuse, but it is a description of what he was going through. He made a series of calls and he which were inappropriate, and he totally lost a sense of what was appropriate. So given that circumstance, he realizes, number one, that he accepts that he just made a decision to have a relationship and have a child with somebody that behaves this way. He realizes that his behavior is incredibly inappropriate. He realizes that it was criminal. And as a result, we have negotiated with the court's approval the probation. I have taken a step further and we're asking the court for deferred status. He does not have a criminal record. He is 45 years old. He does not have. Yeah, he does have some formal education.
So does he live here in San Antonio or is he in El Paso?
At the moment, he lives in San Antonio. Now, if he has expressed to me that if he does take if he begins to struggle again in San Antonio financially, he's going to move back to El Paso with his mom.
But here's the thing, you're not allowed to move anywhere unless you receive permission from the court. Do you understand?
I do.
All right, so this is what the court will do. And what is the name of the mother of your child?
Sadie Kirsch. SADIEAIRAIRSCH.
Sorry, A-R,
The
the last name.
KIRSCH.
Oh. This is what the court is going to do. Court is going to sentence you to 8 years deferred adjudication in cause number 2025 CR 011513-02. There's a $1,200 fine that will be probated. This will run concurrent with 2025 CR 011514. Taking consideration 2025 CC 013418. There's to be 120 hours of community service restitution. 100 of those hours we deem satisfied upon completion of anger management. The remaining 20 hours will be deemed satisfied upon completion of parenting. There's to be a MIC evaluation in custody. There's to be no contact with Sadie Kirsch except through the parental portal. Proof of employment within 45 days of a release. No employment as a home health care provider or with minors. Field visits 1 time per month until further notice. Probation, is there anything? Just one, sorry. There's to be regular reporting by Zoom or in person and regular random UAs. Probation, is there anything else?
Okay.
Is there anything else you need from the court in regards to that cause number?
A question, Your Honor. Were me and my wife are already using a parental app since we're going through.
Well, that's what I'm saying. You'll have to contact, you're only allowed to contact her through a parental app. If you all are in court for civil hearings, of course, you can proceed with that. All right. And cause number 2025 CR 011514. The court will sentence you to 8 years deferred adjudication. $1,200 fine probated. This is to run concurrently with 2025 CR 011513-02. 120 hours of community service restitution. 100 hours deducted for completion of anger management. The remaining 20 deducted for completion of parenting classes. MIC evaluation in custody. No contact with Sadie Kirsch except through the parental portal. proof of employment within 45 days, no employment as a home care provider or with minors, field visits 1 time per month until further notice, and regular reporting by Zoom or in person, and regular random UAs. In each cause number, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Thank you, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I do, Your Honor.
You have to make better choices, right? I know that custody issues, people get heated with that, but you can't do that. You'll have to use the legal system. You understand? All right, good luck to you. Thank you.
Can we get them, read that on the way or?
Yes, let's do that, please.
It's, Rio's on page 1 at the bottom.
Rios, Jerson Rios. Yes, please.
So the last time that we were here, defense had obtained an order from the court to retain a expert.
Yes.
So that was completed. The state did make the motor vehicle available to them. Mr. Brera stated that the expert is just putting the report together. I did give him an offer today, so I believe that he was just waiting for that defense report to be generated. He was gonna give me a copy, but he was requesting a plea deadline.
All right, Ms. Ferguson, I need a plea deadline date. Put it for the end of January, please.
January. January 29th.
All right, Ms. Ferguson, if you'll let Mr. Rios know, your next court date is going to be January 29th for a plea deadline date. All right, thank you. Who's next?
Oh, I'm sorry, Judge. It's gonna be Caitlin Jeffries.
And what page is she on? What page is she on?
She's on the last page, Judge, on page 19, 4 down.
Yes, counsel.
So Judge, you had asked me to confer with probation. The court had signed an order regarding an evaluation for Ms. Jeffrey to potentially be placed in DDRF. But one of the issues we had last time was that she's currently on parole, and we wanted to see what parole would do. And what I was told before we broke last was that she had been ordered to go to safe plea as part of parole. And I think what the court was saying was that you were going to order safe plea to run concurrent, perhaps, with once she's on probation. What we don't want, though, obviously, is for her to have to do safe plea for parole and DDRF for
All right,
probation.
this is my suggestion. If you could get in touch with her parole officer so that parole officer can talk to probation and we'll come up with a solution.
Yes, ma'am.
All right. And I will tell you, I've done a lot of parole hearings in my past, so I know it'll be easy to get in touch with your parole officer.
ma'am.
All right, and then when you're ready to come back, just let us know and we'll figure something out.
Okay, so no court date set for now, and then just reach back out to
Yes.
them later. Okay,
And as soon as that's done, we'll take it up.
okay, Judge.
All right, thank you.
Thank you.
Thank you.
And thank you. Who else?
David Crenshaw, page 14, 3 down.
David Crenshaw.
Yeah, she's in the back.
Oh, you can keep him there. Come forward. What is happening with Mr. Crenshaw?
Judge, we've conferred with the state, and I've conferred with my client. They made an offer, so we can have a plea deadline setting.
All right, I need a plea deadline date.
You want in 3 weeks, Judge, or in mid-January, or
No, put it in the third week of January.
I can do the 20th is a Tuesday, the 22nd is Thursday.
January 20th.
It's a Tuesday.
January 20th.
That's fine.
Okay.
All right, thank you. Thank you, counsel.
You're welcome, Judge.
All right, who's next?
Eric Mason, page 5, 4 down.
Eric Mason. Hi.
So Judge, today was the plea deadline. We've decided we want to go to trial.
All right. How long do y'all expect this trial to last?
Maybe 3.
All right, Ms. Ferguson, I need a 3-day jury trial date.
Yes, ma'am. I can do February 2nd.
I think I'm gonna be out that week, Judge, for a seminar.
All right.
February 23rd.
Perfect.
All right, your jury trial date is going to be February 23rd. Your plea deadline date has expired. The court will not consider any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand? All right, thank you.
Judge, have a great day. See
Oh,
you
you
later.
too. Bye. Counsel, if you can make sure that you've signed all discovery acknowledgements on Mr. Mason. All right, who else?
Vincent Gonzalez, he's on page 5 going down.
Vincent Gonzalez.
Vincent Gonzalez.
He's in the back, Judge.
Oh, that's fine.
We have Vincent Gonzalez.
Judge said it was okay.
He's gonna get a.
All right, what's happening with this case?
He can stay.
Yes, Your Honor, I received the discovery that was missing
Oh, I'm
today.
so sorry. Ms. Ferguson, what page is that again?
Page 5, Judge. He's on page 5. he's
Ah.
on several pages.
All right, so you received a discovery?
Yes, Your Honor. And I'm asking additional time for a plea deadline.
All right, Norma,
Yes, ma'am.
set this for a plea on that Thursday in the first week. There'll be no further extensions.
January 8th.
All right, your plea deadline date is going to be January 8th.
I have a vacation on file
For when?
until January the 12th.
All right, Norma, set this for a jury trial date and a plea deadline date after January 12th.
I can do the 13th, Judge.
All right, we'll be back on January 13th. That'll be your jury trial date and your plea deadline date.
Yes, Your Honor, and I have a question. Is it a good time to address motion to set bond? I've conferred with the state.
No.
Okay.
All right. We'll make sure that that's sent to Judge Naharada here. You know, he didn't make it last time either because the bus broke down. All right, who's next?
It's John Ramirez, page 17, 4 down.
John Ramirez. All right, counsel, are you proceeding on the motion to revoke?
Your Honor, it's our understanding that the state, in conjunction with probation, are asking that he be terminated unsatisfactory.
All right, so does anyone have any paperwork for me?
So I didn't know if we were gonna just move forward with NCR or if we're gonna withdraw and ask that the court go along with the.
Do y'all want to withdraw?
Sure. I think the consensus, if the court's okay with that.
All right.
we're allowed to withdraw.
And so the mental health issues have been addressed?
Yes, Judge.
Okay.
Regarding that, Judge, speaking to my client in more depth, like, he did tell me that he suffered a hit and run in his mid-20s, and that left him with the traumatic brain injury as well as rods having been placed on the right side of his full body. So he's been experiencing chronic pain. He's looking to get that addressed medically and also to see a doctor. He has an appointment to see a doctor next week to address his physical issues, Judge.
Okay.
And that's why he missed a couple of the drug tests. But other than that, Judge, been no usage. His sister is his payee. He gets disability for his issues.
Okay.
She also attested that there's no issue to the drugs, and he's been on since 2017, Your Honor.
Okay. All right. All right. Thank you. Thank you. Thank you. All right. Who's next? We need to clear out the box.
Nicholas Humus, page 8, 3 down.
Nicholas Kionis. All right. What is happening with your case?
This is Mr. Quinones' first time in court on this case.
Okay.
He was supposed to be here on the 10th of October, but there was some confusion. Both myself and Mr. Jeffrey Scott are representing him, and we kind of just got crossways. Our wires crossed on it. I'm on the bond. What I'm asking the court to do is consider withdrawing the judge's warrant, giving us some time to come back and review the case together, consider the offer. But I've already conferred with the state about the case and about a possible offer.
All right. So because of the changes in the law, we'll have to have a full blown hearing, and I can't do that today.
Okay,
We can have it referred to Judge Nahara for a hearing on that.
that's fine.
Because tomorrow I have mental health court issues to take care of. All right, Ms. Ferguson,
Yes, ma'am.
they want a bond on this case, so refer that to Judge, they're asking for a reinstatement of the bond. You need to refer that to Judge Nahara or Judge Halstead.
Yes, ma'am.
Judge, my question though was the bond was a bond forfeited? Because it looked
Oh,
like
it was a judge's warrant.
Right, so would we just, since my understanding procedurally, we would just need the court to withdraw the judge's warrant.
The bond laws have changed, so I can't just withdraw the warrant. There has to be a hearing.
Okay.
All right. All right, so what we can do, Norma, see if you can see if Judge Nahara or Halstead is available for tomorrow. If they're not, I'll take it up tomorrow.
Okay.
All right, thank you.
Thank you, Your Honor.
Thank you. Anyone else?
Darian Fish is a plea judge. Do you have that paperwork?
No, I do not. And we're gonna have to do that tomorrow, and we can take it up by Zoom because
We have a lot of, we have one.
I have two plea
three.
papers. No, we need to take it up by Zoom because the deputies have to transport them back. And if they don't have them out of here by, well, before 5:30, they have to transfer them back. They're gonna miss the bus.
Okay.
So everyone, make sure that everybody's sworn in, and I will take you up tomorrow by Zoom. And Norma, at the jail, they can appear by Zoom.
Your Honor, Mr. Lozano, we had a plea deadline date. I was just saying, I think he might have been next because you just called Mr. Fish.
Mhm.
We're not accepting the offer and we just need a trial date.
All right, and that's Lozano.
Yes,
What
Your Honor.
page is Lozano on?
Let me look at.
No, we're not accepting the offer.
Page 5, 2 down.
All right, Mr. Lozano. How long do y'all expect this trial to last?
4 days, Your Honor.
All right, Ms. Ferguson, 4 days.
March 24th, Judge.
All right, your jury trial date is going to be March 24th. Mr. Lozano, your plea deadline date has expired. The court will not accept any plea bargain agreements without good cause. Otherwise, you have to plead open to the court. All right, thank
Your
you.
Honor, I don't know that 4 is a good announcement on this because this is a rape case with a lot of witnesses.
All right, well, it'll be set for March 24th.
Okay.
All right, thank
Yes,
you. Yes, thank you.
So March 24th is the trial date, we will be moving. Yes. And on Mr. Fish.
That'll be done by Zoom, and everybody needs to be here by Zoom.
At
So
what
you
time?
can zoom in tomorrow too?
Yes, you can Zoom in tomorrow. And Norma, put it at 11:30.
doctor's appointment. Have that
Mhm.
appointment.
Yes.
Can we set it for some time?
You talking about Padilla? Who are you talking about?
On Vargas.
Marcus, it's a plea, Judge.
What page is that?
You got it, page 8 at the bottom.
Is Vargas in custody or on bond?
It's in custody. They just took him back right now.
All right, so what we can do, Norma, bring that back then for a plea the first week and, because you're not available tomorrow, right? All right, oh, no. Norma, bring that back for the first week in, January for a plea.
I can do that for that.
All right, so we'll come back on January 5th for a plea.
All right.
Thank you.
Do I need to sign something?
No.
Okay.
And Your Honor, is it okay if we just need a plea deadline date for Mr. Fish?
No, I think
We got-
today is his plea deadline date.
But we didn't have an offer, Judge. And where's Alyssa?
There is an offer.
Yeah, they made one today. This is the one I was on, but it's just.
Yeah. so let me go.
Sorry, go on.
Well, that's, you know.
Does Michael need to be sworn in right now?
I already spoke her in.
We already did.
All right, thank you.
Arias, right?
Yeah,
Arias?
she just went in. Oh, perfect. Okay.
He was just waiting.
No, today is the plea deadline date. It's been extended. There was a plea deadline date on November 18th.
I'll see you tomorrow.
Then it was extended to December 9th, and now we're here. That's what's in the notes.
Yeah, that's, well, Your Honor, he wasn't accepting what so we can get a trial date for him too.
All right, Norm, I need a jury trial date on Mr. Fish. Yeah, it shouldn't take that long.
That one, I'd say maybe,
You want to put that the first week in January?
so I wouldn't even think 3 days.
January
I'll take maybe 3 days.
All right, January 5th.
January 5th, thank you. January 6th, a bad day, Judge?
Yes.
I might not be in town up there. That's the only reason I'm asking.
No,
I'll be in Hawaii.
Well, we'll see. All right, everyone. I hope everyone have happy